though, and or whoever's going to be there the day that I'm scheduled for the 26th, Judge Oakley.
So that's the day for the pretrial, Mary Ann. You've already set that for him?
That's the date she gave me, but I don't know if she's on.
Did she give you a time?
Yes, 10:45 on March 26th.
March the 26th, 2025 at 10:45 a.m. That is not with me. That is
Judge Oakley.
I was gonna say that's with Judge Oakley.
Yeah, only because I have a jury trial and I'm out of town the first 2 dates she offered.
No worries. Mr. Harris Salam, court staff will send you notice of that pretrial date, March the 26th, 2025, 10:45 a.m. That's in person with Chief Judge Brian Oakley in courtroom number 2. Mr. Schwartz, is there anything else this morning?
I just want to thank the court and your staff for moving this up for me, accommodating my schedule. Thank you.
No worries, sir. Have a good day.
Yep, bye.
Mr. Harris Salam, have a good day, sir. Mr. Mohammed, this was 250128 SD. Mr. Schwartz had another court that he had to get to. We just arraigned Mr. Harris Salam and set the pretrial date on March the 26th.
Judge, just for your information, the defendant that's in Wayne County right now on screen is defendant Uribe, Uribe.
Thank you. And his attorney is here. I've seen Ms. Suguera in the breakout room. Good morning, Mr. Nunley. Thank you.
Morning, Judge. How are you?
I'm super. How are you, sir?
Excellent. Thank you. Mary Ann, are there breakout rooms?
Hi, Royce. Yes. Let me make you co-host. I'm sorry.
That's okay. Thank you.
There you go. Yep, you're welcome.
Good morning, Ms. Mandernack.
Good morning, Judge. How are you?
I'm super. How are you?
I am super as well. Thank you for asking. Oh, we have Mr. Nunley here today.
Thank you. I had no idea. I'm watching. Good morning, Ms. Segura.
Good morning, Your Honor.
Do you need to speak to Mr. Uribe?
No, I am good. I'm gonna have to set up a visit with him.
This is 250153 FY State of Michigan versus No Uribe Cifuentes. May I have your appearances?
Yes, good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service, P86432, appearing on behalf of Mr. Cifuentes. I believe, is there a Spanish interpreter? Because he needs one.
No, there is not one here.
There was not an interpreter indicated or requested. Do we need to
Okay.
adjourn this over for a week?
We might. I have him on another case in Taylor, and they had a Spanish interpreter there for him. So I don't believe he is fluent in English.
Let's get him unmuted at least to get his name if we possibly could. Mr. Cifuentes?
Good morning, Your Honor and staff. This is Deputy Provencio, Wayne County Jail.
Good morning, Deputy. I needed him to identify himself. Would you state your name for me, please, sir?
I'm not the person on record. My name's Jacob Michael Shepard.
That is not who I was told. I was looking for No Uribe Cifuentes.
I do have him, Your Honor. We're going to flip him out right now.
Thank you.
And Your Honor, he does need an interpreter. Come on.
Thank you.
Venga aquí, por favor. You got it.
Thank you.
Thank you. Based on that, Ms. Segura, unless there's some other objection or way you want to move, I want to put this case over for a week so we can have an interpreter present.
Yes, Judge, that is totally fine with me. I understand.
Sir, would you state your name for me?
Noé Uribe Cifuentes.
Ms. Segura?
Yes, Judge. As we indicated off the record, Mr. Cifuentes is in need of a Spanish interpreter. I unfortunately cannot speak Spanish, so I don't want to hold this PCC without him understanding as to what's going on. So I would ask for a 1-week adjournment so that we can get that Spanish interpreter here.
Yes, please. I would like to get an interpreter, please.
March, absolutely. March 12, 2025 at 8:30 a.m. Back here on Zoom with me, Judge Martin in courtroom number 1. We've made notation in the file that a Spanish interpreter is needed. My secretary will get on that right away. Ms. Segura, was there anything else?
No, Judge, that is all. Thank you so much.
Thank you.
All set, Your Honor?
We are. Thank you so much for watching.
Okay.
Grab the car, take him back. Your Honor, ma'am, I have Jacob Shepard, Gregory Pugh, and Mason Housley.
Thank you.
Mhm.
Ms. Johnson, were you expecting Mr. Noakes to come out?
Yes, Judge, I was. I thought we were all set in there.
Trying to get us moving this morning and nobody's cooperating. Good morning, Mr. Noakes.
Good morning, Your Honor. Oh, that's
Do you need a moment with Mr. Reed?
sure.
We'll get you moved into a breakout. As soon as you come back out, I'll call your case.
Your Honor, we're ready on Reed.
And I know, Mr. Noakes, I just had to pull your client back out into this main session.
Okay.
This is 250098 FY State of Michigan versus Curtis Reed. May I have your names for the record, please?
Good morning, Your Honor. Brittany Johnson on behalf of the people, P83513.
Good morning. May it please this honorable court, William Noakes, P42796 of the Neighborhood Defender Service of Detroit, on behalf of Mr. Curtis Reed, who's present via Zoom and consents to hold this hearing via Zoom. Mr. Reed, please tell the judge your name.
Curtis Cortez Reed Jr.
Thank you, Mr. Reed. Today is the day and time scheduled for the PCC. Mr. Noakes, how are we proceeding?
We're requesting an exam, and having discussed the matter with APA Johnson, the earliest that we could both be available would be April 18th. Is that a possibility?
It is not, Mr. Noakes. We do our exams on Wednesdays. I am back on criminal on, if it's April the 16th or April the 23rd. If you're saying the 18th is the earliest, then I'm looking at the 23rd.
Well, I understand APA Johnson's going to be in trial then. So the 23rd would have to be the day.
Judge, unfortunately, I'm also starting a child abuse first trial on the 21st. I expect it's going to go through the 23rd.
Because you are a special, we can do it on an off day, but Mr. Noakes, before we schedule the exam, I want to disclose on the record that I'm married to an elected official in Van Buren Township. I make the disclosure as Van Buren Township is the police agency involved in this matter. My husband's not involved in the day-to-day operations of the Public Safety Department. He doesn't know anything about this case. He doesn't even know that it's scheduled. Do you need to have a conversation with Mr. Reed, or are you prepared to proceed with the scheduling?
No, I think we're prepared to proceed, Your Honor. I don't think there's going to be any impediment to our getting a fair hearing.
And Ms. Johnson, you said your trial is projected to go what dates again, ma'am?
The whole week of the 21st. I do have another one starting on the 28th, but I expect it to be significantly shorter. I could do the afternoon of the 30th. Or at least as late as you could get us.
Well,
If Mr. Noakes is available on the 30th.
no, could we do the 18th? Because as of the 28th of April, I will be out of the country.
April the 18th is Good Friday and the court is closed.
Ah,
So then I'm looking. And you, Ms. Johnson, the trial is going to go the whole week of April the 21st?
We're due to start on the 21st, Judge. I think I could probably safely schedule us on the 25th. And then worst case, I could have someone else from my unit come.
How
Well,
long would you project this exam? I'm sorry, Mr. Noakes.
frankly, the 25th is out for me because I will be attending a board meeting in Chicago that day.
And we can't do it any earlier, any sooner.
Well, there's a possibility of, let's see, April 9th.
I'm completely open that day.
Are you
Then-
really? Wait a
April
minute.
9th.
We can do April 9th if you don't mind the afternoon.
Beautiful.
No, that's perfectly fine.
Live exam. April the 9th. How many witnesses would you project, Ms. Johnson?
One at most, Judge, two.
Let's say 1:30 on April the 9th. And that's in person in courtroom number 1 here at the 34th District Court. It is the only thing that the court will have scheduled in the afternoon. The only thing that this courtroom will have scheduled, there will be criminal going on somewhere else in the building, but this is the only thing I have scheduled. So if something changes between now and April the 4th at 1:30 p.m., reach out to Mary Ann and let her know. Was there anything else, Miss? I'm sorry.
So we're going to have it on April 9th at 1:30.
Yes, sir.
Okay.
Anything else, Miss Johnson?
Just that I'll have discovery over to Mr. Noakes by this afternoon at the latest.
Well, thank you. And thank you, Your Honor. Mr. Reed, I'll be in touch with you so we can discuss the outlines of your case.
All right, thank you.
Have a
You're
good
welcome.
afternoon, Mr. Noakes. Mr. Rita, we'll see you on April 9th in person, 1:30 in courtroom number 1. Court staff will mail you notice. Have a good day, everyone.
Thank you, Judge.
Your, and Your Honor, I'll be back in a little bit because I've got 2 more PCCs.
I thought you have, are you with Mr. Shepherd, who's in custody?
Yes, Mr. Shepherd and, hang on a second, Mr. Shepherd and Mr. Brock.
Do you need to go somewhere else right now?
Yes, Your Honor, I've got
Okay.
to be in court. So
When you come back, I'll
be
have
back
Shepherd and
on it.
Brock on the side waiting for you. Thank you, sir.
All right, thank you.
Ms. Mandernack, were you ready with something?
Oh, no, I was just gonna speak with Mr. Noakes about Shepard, but he'll be back, so.
I could tell that he was standing in the hallway or somewhere else, so.
Oh, yes, we're always doing that. It's the nice thing, my favorite thing about this docket is, I only have to be in one place for the whole day.
The people are here waiting. Mr. Gaines, Ms. Collins, Mr. Knowles have been here for quite some time. I want them to know that their attorneys are, some of the attorneys are in the breakout speaking with the prosecutor. As soon as they pop out, I'll get your cases called. I thank you for your patience this morning. It looks like activity in that room. I just am not seeing enough attorneys come out fast enough, Ms. Mandernack.
I'm in no rush, Judge.
I know you're not, but I don't want people to think that nothing's going on. It just is not visible on this screen, but it looks like a lot of activity in the.
Oh,
breakout.
absolutely. You pull up the breakout room screen and you can tell a lot's going on.
Thank you. No.
Good morning, Madam Clerk.
Good morning, Mr. Nasser.
How are you?
I'm fine. How are you, sir?
Very well, thank you. I'm hearing Kayla Collins, please.
Ms. Collins is here. Do you want to go on with the prosecutor first, or do you want Ms. Collins first?
No, I've spoken to Kayla already. If I may speak to the prosecutor, please.
Absolutely. We'll get you moved into his breakout room. This is 5S4490514ST. This is State of Michigan versus Ward Trucking. This case was scheduled at 8:45. The court has received information from the prosecutor that this case is to be dismissed. It is in fact dismissed.
Your Honor, my daughter's a little fussy. I'm just gonna step out for a moment to get her situated.
Understood, Ms. Collins. Thanks for letting me know.
I can leave yours.
Mr. Johnson, is your client with you by chance?
No, I can get them on if that's okay.
Absolutely.
Okay, will do. Thanks.
Hi, Ms. Madenak.
Oh, good morning. How are you?
I'm good, and you? Are you in a meeting with some other attorney right now?
No, we're just in the general room. I can speak with you
Okay, cool.
in a breakout room in just a minute if you'd like.
Yeah, it's fine.
Okay.
And then when we are done, can you put me in a breakout room with another client, or do I need to go back to Mohammed?
either the clerk or myself can put you in another breakout room. You said after I talk to you, you want to go to Mohammed?
No, I want to go to Desmond Stevens if that's something you can manage.
Okay,
Actually,
yeah,
Ms.
we can-
Frederick, unless you have any objection, we'll make you co-host so you're able to move yourself around.
I'm not familiar, Judge.
Oh, okay.
I could be like in the Twilight Zone if I did this by myself.
No worries.
Sorry.
No worries.
Miss Mandernack, can you hear me?
Yeah.
Are you ready to talk to me?
Yeah, I just don't know if the court wants me to stay in here because I think Mr. Johnson and I should be ready on another case in just a moment.
Oh, okay.
Well, he's not scheduled until 9:45, so coming on early is a privilege, not a right. So if you want to go with Ms. Frederick, that's fine with me.
Okay, perfect, Judge.
Thank you, Judge.
You're welcome.
Motion, right?
Yeah, okay.
Mr. Nasser, are we ready with Ms. Collins?
Yes, Judge, we are.
This is 250015 FY. This is State of Michigan versus Kayla Collins. May I have your names for the record, please?
Good morning, Your Honor, and to your staff. May it please the most honorable court, Mohammed Nasser, P74485, appearing on behalf of witness Kayla Collins, who appears via Zoom, consents to the hearing over Zoom. Ms. Collins, please state your full name for the record.
Kayla Ann Collins.
Thank you, Ms. Collins. Today is the day and time scheduled for the PCC. Mr. Nasser, how are we proceeding?
Judge, if it may please the court, I've talked to the prosecutor. I believe we have a resolution intact. It just requires some finalization. I'd ask for one final PCC. Prosecutor Mohammed indicated 1 week would be more than sufficient, so I'd ask for a continuance of only 1 week.
That will put us on March the 12th at
10 o'clock, Judge.
Ms. Collins, your case is being adjourned over to next Wednesday, March the 12th, 2025 at 10 a.m. That's back here with me, Judge Martin, by Zoom in courtroom number 1. Court staff will mail you notice of the new date and time. Is there anything else in this case, Mr. Nasser?
Not for defense. We thank this honorable court.
Have a good day. Ms. Collins, you're free to go. Have a good day.
See you next week, Judge.
Thank you.
Thanks.
Ms. Frederick, are you ready with your cases, ma'am?
I am. I just have to find Miss Woolfolk. Can you see a Diamond Woolfolk in the gallery, Judge?
What am I supposed to do?
I don't, Woolfolk, I don't see that person. I see for you, Gaines, Knowles, and Stevens.
Right, and I had a young woman by the name of Diamond Woolfolk. It's an older case, so I'm concerned that maybe she may have moved and didn't get the information necessary to appear today. So if the court can let that one go last and I can try and track down a phone number or something.
Absolutely. Let's start with Mr. Gaines in 240626 FY, State of Michigan versus DeAndre Gaines. May I have your names for the record, please?
That's going to be Mohammed's case, Judge.
He's not going to come out of the breakout unless he has to.
Okay, so basically, Your Honor, my name is Lisa Frederick, P53372. Counsel and I have agreed to adjourn this matter. We're considering a delayed sentence on the case, and the stipulation is restitution, complete and total. So,
Ms. Frederick, I'm sorry to interrupt your comments. Mr. Gaines, your name for the record, sir.
DeAndre Gaines.
Thank you. Ms. Frederick.
Yes. Should I proceed?
Yes, please proceed now, ma'am. I'm sorry.
Okay, no worries. Thank you, Judge. So ultimately, we only have one question, and that is we have two different restitution amounts. And I would like for Mr. Mohammed to confirm one or the other. And other than that, my client has indicated he would need about 6 months. So I'd ask the court to set this matter out or adjourn it for 6 months, giving him an opportunity to pay the restitution in full. Also giving Mr. Mohammed an opportunity to confirm one amount or the other.
Respectfully, Ms. Frederick, this court would not adjourn a case for 6 months for somebody to make payment on restitution. What we could do is set it over for a plea, and then you could back the restitution into that. I'm
So
not
that's
sure.
what I thought. I'm sorry, Judge.
I
So-
would never adjourn a felony case for 6 months for that reason.
Right, and so that was my understanding of how this works, but so Mr. Mohammed has indicated that he's going to reduce it to a misdemeanor for this purpose, which is why I thought he should be here.
Or you, I didn't get that when you came out of the breakout room. I didn't understand that your client was going to enter a plea this morning. Is that
No,
what you're
see,
trying to
that's what I
do?
was saying. Mr. Mohammed indicated he wanted to reduce the felony to a misdemeanor and allow him time to pay the restitution in full before making the offer for a delayed sentence. And so, it kind of was something I wanted him to explain to the court.
So we'll pass the matter.
Okay,
Mr. Mohammed's still in his breakout with some other attorneys. I'll call your other two cases and we'll get Mr. Mohammed out for that. Let's go to Mr. Knowles, 240817 FY, State of Michigan versus Jermaine Knowles.
Lisa Frederick, P 53372, appearing on behalf of Mr. Knowles, who is also present in the Zoom, Your Honor.
State your name for me, please, sir.
Jermaine Knowles.
Thank you. Ms. Frederick, how are we proceeding with this PCC?
Your Honor, I would like to set this matter for a preliminary examination.
Is discovery complete?
Thus far, yes. I think that the case is 4 years old, so I'm gonna kind of make sure that I have everything, but so far it looks like I have everything.
Will you be ready next week? Next Wednesday, the 12th?
Give me 2 seconds, Judge. Yes, ma'am.
11:30, Judge.
Thank you. Mr. Knowles, your preliminary examination is being scheduled for next Wednesday, March the 12th, 2025 at 11:30 a.m. That will be in person in courtroom number 1 with me, Judge Martin. Notice of that date and time will be sent to you next Wednesday,
Okay.
11:30 a.m. I'm sorry. Were you saying something, Mr. Knowles?
You say 11 a.m.?
11:30 a.m., sir, in courtroom number 1 at the 34th District Court. Is there anything
Okay.
else in this case, Ms. Frederick?
Nothing else, Your Honor.
Thank you. Mr.
Thank you,
Knowles,
Judge.
you're free to go. I will see you next Wednesday at 11:30. Have a good day, sir.
And I'll be in touch, sir.
Thank you. You too.
250142 FY, State of Michigan versus Desmond Stevens. May I have your names for the record, please?
Desmond Stevens. Desmond
Thank you. Ms. Frederick, today was the day and time scheduled for PCC in this matter. How are we proceeding?
I was hoping to get into a breakout room with Mr. Stevens, Your Honor. There's been an offer made on the case, and I think that my client would likely avail himself of the offer.
Absolutely. We'll get you moved into a breakout room with Mr. Stevens.
Thank you.
This is 161257 SM, State of Michigan versus Nolis King. May I have your
Good morning.
appearances, please?
Good morning, Your Honor. Patricia Mandernack for the people, P 84088.
Mr. Johnson?
Sorry about that. Trouble unmuting. May it please the court, Vassal Johnson II, 72130 on behalf of Mr. King, present on Zoom.
Thank you. Mr. King, unmute yourself. State your name for me, please, sir.
Oh, Knowles King.
Thank you, sir. Today is the day and time scheduled for pretrial on this matter. Mr. Johnson, how are we proceeding?
Judge, if I may.
Absolutely.
Thank you, Your Honor. Judge, this is a case from 2016. I have attempted to contact complaining witness in this case. The phone number that we have for her is out of service. I am unable to proceed without her.
Judge, you move to dismiss.
Any response to the motion, Ms. Mandernack?
No objection, as long as it's
Thank you.
obviously without prejudice.
Mr. King, the court will grant your attorney's motion to dismiss. This case is hereby dismissed. Ms. Mandernack, anything else on behalf of the people?
No, Your Honor.
Anything else, Mr. Johnson?
No, Your Honor, thank you.
Thank you. Mr. King, you're free to go. You have a good afternoon, sir.
Thank you.
Have a good day, everyone.
You too. Thank you. Ms. Mandranak, Mr. Noakes is in your waiting room.
Oh, I'm sorry, Judge, I didn't realize that.
He just popped in there.
I wish there was a way it would ping or notify me when someone went in my waiting room. Because I feel so bad when that happens. I'll go in there with him right now.
Thank you. Ms. Frederick, are you ready with Mr. Stevens?
Yes, Your Honor, I am.
I'll move him out here. Let me get him out here into the main session, and then when we're done with Mr. Stevens, we'll pull Mr. Mohammed out so that we can return to Mr. Gaines.
Okay.
This is 250142 FY State of Michigan versus Desmond Stevens.
Yes, Your Honor. Lisa Frederick, P53372, appearing on behalf of Mr. Desmond Stevens, who's also present via Zoom.
Sir, unmute yourself. State your name for me, please.
Desmond Stevens.
Thank you. Ms. Frederick, you've now had the opportunity to speak to your client. How are we proceeding with this PCC?
Thank you, Your Honor. Mr. Muhammad did make an offer to my client of a 90-day misdemeanor obtaining a pistol without a license, and some terms and conditions, obviously. My client wishes to avail himself of that offer.
The court hasn't received the write-up from Mr. Mohammed as of yet, but I take your word as an officer of the court. Mr. Stevens, raise your right hand for me, please, sir. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may put your hand down. Sir, you understand that if the court accepts your plea this morning, you will not have a trial of any kind.
Yes.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
I understand.
And sir, you're entering this plea freely and voluntarily?
Yes. Yes, ma'am.
You haven't been threatened in any way or promised anything to get you to plead guilty?
No, ma'am.
Are you pleading guilty because you are in fact guilty?
Yes, ma'am.
Sir, is it true that on July 31st, 2024, Detroit Metro Airport, which is located in the city of Romulus, County of Wayne, state of Michigan, you obtained a pistol without getting the proper licensing?
That is true.
Ms. Frederick, would you like to inquire further of your client?
No, Your Honor, thank you.
Mr. Stevens, the court will accept your plea of guilty to the reduced count of obtaining a pistol without a license. Ms. Frederick, what were the terms agreed to between yourself and Mr. Mohammed?
So I just wanted to make sure that I have them all, but it is my understanding that my client would be on probation for a term of 90 days and forfeit the firearm in question.
And that's it?
That's all I have in my notes, which is why, I mean, of course, I would like to have Mr. Muhammad confirm it. But that is what I have.
Then give me one moment. We'll interrupt him so that we can finish Mr. Stevens and Mr.
Gaines.
Gaines, yes.
Thank you.
I'm just looking to. Mr. Mohammed, I am so sorry to interrupt your breakout room, but I want to confirm two cases that were pleased this morning. We have Mr. Desmond Stevens pled to the reduced count of obtaining a pistol without a license.
Correct, Judge. My apologies, I didn't write that up yet. It was obtaining a pistol without a license with a stipulation that the defendant will forfeit the firearm and cannot possess any firearms while on probation. And then he would be subject to a PSI.
Okay, that's the term I missed, Judge.
Okay. Thank you. Mr. Stevens, the court is going to refer you to the probation department for PSI, which is the interview that you will need to conduct with Mr. Grant, who is this court's probation officer. Your sentence will not exceed the agreed upon terms of the forfeiture of the gun and 90 days of probation. But Mr. Grant will be in contact with you by phone and by email. There will be an interview for you to submit to, form for you to complete. And then he will schedule you to return to this courtroom for sentence to be imposed. Ms. Frederick, will you continue to travel with Mr. Stevens through sentencing?
Absolutely, Judge. Thank you.
Okay. Was there anything else in this case, Ms. Frederick?
Nothing else, Your Honor.
Then Mr. Stevens, you're free to go. Mr. Grant will be in contact with you to get your PSI completed, sir.
Okay, thank you. Y'all have a great day.
You too. Thank you, sir.
No problem.
This is 240626 FY. This is State of Michigan versus DeAndre Gaines.
Good afternoon, or good morning, Your Honor. Mohammed on behalf of the people.
Good morning, Your Honor. Lisa Frederick, P53372 on behalf of Mr. DeAndre Gaines. Shall I proceed, Your Honor?
Yes, please.
So basically, what I was trying to indicate to the court is that the terms for the offer were somewhat murky for me. I understand that we have two different amounts or values with respect to the restitution. Counsel had discussed a delayed sentence upon full restitution. However, the court was not inclined to set the matter out far enough for Mr. Gaines to make full restitution. So we needed to kind of sort that out with Mr. Muhammad to find out how, in fact, we could do the delay and make the payments.
Ms. Frederick, I was not clear that that is what you were saying. If your client is pleading today to a charge with a delayed sentence and restitution during that delayed sentence, we can do that, but that's not
what Mr.
the
Muhammad
information that's okay.
No, Mr. Muhammad said that he would not be inclined to make the offer unless there was full restitution, which is what
Ms. Frederick, what I'm saying to you is that the issue is not the restitution. It was when you said to me, with the court adjourn it, put it over for 6 months. It wasn't, I wasn't clear that you were saying the 6 months would be within the confines of a delayed sentence. If your client, Mr. Gaines, is pleading to something this morning, and the agreement between yourself and Mr. Muhammad is that he's pleading with a delayed sentence of 6 months, and during that 6 months, he will pay this restitution and any other conditions put in place by the court. If you're saying the latter, we can absolutely do that.
No, Your Honor, what I was saying was it was as murky as I presented it. Mr. Muhammad said he would not be inclined to make the offer today. In fact, he said that he wanted full restitution before he made the offer and recommended an adjournment.
Oh,
that's what I was, it's not my explanation of it. It's what I was told.
So Judge, in regards to the plea offer, I would be okay with it, but there would have to be full restitution due at sentencing. That's what I was trying to relay to defense, is for me to do it under a delayed, full restitution would have to come due at sentencing.
Then that's a conversation between the two of you, and it doesn't sound like there's an agreement this morning. I'm not trying to put words in anyone's mouth, but that's what I'm picking up from what both of you were putting down.
Well, Judge, where we left off is she was going to speak to her client and let me know if he can make full restitution and then come back and speak to me. And that's where I left off. I didn't know that they were going to accept it or do anything of that nature. I was just waiting for her to come back.
Oh, Ms. Frederick indicated that there were two different
I won't.
restitution amounts proffered, so that might be part of the issue.
So in regards to the two restitution amounts, the complaint states that the employee admitted to stealing $4,854, but then the next sentence says Amazon officials stated he was responsible for $5,483. So that's where the confusion is with the two numbers. But I would be deferring to that second number.
Mr. Muhammad, because there does not seem to be a firm agreement, then we don't need to finish this conversation on the record. We can do one of two things. You all can go back in the breakout room and speak, or we can adjourn the PCC over to allow time for the two of you to communicate off the record, and maybe at the adjourned PCC, you will have come to some terms regarding Mr. Gaines' ability to make restitution payment or some other offer, agreement, plea.
Understood. I would respectfully request a 1-week adjournment, and then we can discuss it outside of the court and come to an agreement, hopefully.
Ms. Frederick, would that give you sufficient time with your client to follow up and figure out if restitution in full was available or possible?
Yes, Your Honor, but I just want to say that exactly how I explained those terms is exactly what Mr. Muhammad told me. Okay, so I wasn't confused at all. I was perplexed, but not confused.
I was the one that was confused, Ms. Frederick. I wasn't putting that on anyone. But
Okay.
if 1 week will give you sufficient time with Mr. Gaines, that's fine with me.
I just
Or
need
if you-
counsel to give me verification. That's it. So yes, I'll take the week, Judge.
At 10 o'clock, Judge.
Thank you. March the 12th at 10 a.m. back here on Zoom with me, Judge Martin, in courtroom number 1. Mr. Gaines, court staff will mail you notice of that new date and time, but it's next Wednesday, 10 a.m. on Zoom. Was there anything else in this case, Mr. Muhammad?
No, thank you.
Anything else, Ms. Frederick?
No, Judge, thank you.
Thank you. Mr. Gaines, you're free to go. You have a wonderful afternoon, sir.
You too.
Yeah.
There was a defendant scheduled at 9 o'clock and he is in treatment. Defendant has a tumor and treatment still just handling.
I saw that.
Do you want to just hold on?
Mm-mm.
Okay, sure.
Who's the attorney? Yeah, pull him out so we can get him released, please and thank you. Oh. (220470) State of Michigan versus Diamond Woolfolk. May I have your names for the record, please?
Diamond Woolfolk.
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
Good morning, Your Honor. Lisa Frederick, P53372, appearing on behalf of Ms. Woolfolk.
Thank you. Today is the day and time scheduled for PCC. For the PCC in this matter, how are we proceeding?
Yes, Judge, on behalf of Ms. Woolfolk, I'd like to set the matter for preliminary examination, and if we could have the 12th of March, I would appreciate it.
Absolutely. Give me one moment to get a time from Mary Ann.
11:30.
Okay, so
Ms.
you know that
Woolfolk,
we have
you're-
Mr. Knowles at 11:30.
We scheduled 2 because
Okay.
we scheduled them in approximately half-hour blocks, and if there's a waiver or plea.
Very well, Judge.
Ms.
you, Your Honor.
Woolfolk, your in-person preliminary examination is next Wednesday, March the 12th at 11:30 a.m. That's in courtroom number 1 here at 34th District Court with me, Judge Martin. Court staff will mail you notice of that new date and time. Ms. Mandernack, is there anything else on behalf of the people?
No, Your Honor.
Ms. Frederick, anything else on behalf of Ms. Woolfolk?
Yes, Your Honor, I would appreciate it if I could be placed in a breakout room with Ms. Woolfolk, as I do not have an accurate phone number for her.
Oh, absolutely. Mary Ann will get you moved into a breakout room with her.
Thank you, Judge, and have a great day.
You too, ma'am. Good to see you.
You too.
Edward Brown. When all these fucking people are now.
Brown. What can Brown do for you? Thank you. Mr. Noakes, are we ready to talk to Mr. Shepherd now?
Yes, Your Honor.
Pravachi will get Shepherd pulled into the room.
Your Honor, good morning. I got the 3 defendants, Housley,
Jacob-
Pugh, and Shepherd. Oh,
Jacob Shepherd, please.
yes, ma'am.
Thank you.
Your Honor, ma'am, I am defendant, Mr. Shepherd.
Thank you. Did you need to speak to him, Mr. Noakes? Mr. Heisley?
Yes, I'm here.
This is 4S44656788. This is State of Michigan versus Alfredo Hernandez.
Yes, that's what I have.
This case was scheduled at 9 o'clock. It's now 9:41 by this court's clock. I'm double checking our breakout rooms. It does not appear that Mr. Hernandez has appeared this morning. I don't want to continue to hold you indefinitely. This court will deem him as having failed to appear. Thank you. And will issue a bench warrant 5,010%. Did you need anything else from the court this morning, sir?
No, I don't. Thank you, Your Honor.
Thank you. Have a good day.
You too. Bye-bye.
Thank you. Mr. Noakes, did you speak to Mr. Shepherd or are you ready with Mr. Brock? What were we
No,
doing?
I spoke to Mr. Shepherd. We're ready. We're simply going to request an exam date.
Then let's get Mr. Shepherd back out here. What happened to him?
I'm pulling him out, Judge.
Thank you. This is 250157 FY. This is State of Michigan versus Jacob Shepherd. May I have your names for the record, please?
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
May it please this honorable court, William Noakes, P42796 of the Neighborhood Defender Service of Detroit, on behalf of Mr. Jacob Shepherd. Mr. Shepherd, please tell the judge your name.
Jacob Michael Shepherd.
Thank you, Mr. Shepherd. Today was the day and time scheduled for the PCC. Mr. Noakes, you indicated that you're demanding the exam be scheduled, sir?
That's correct. And if at all possible, April 9th would be a good day.
April 9th is not a good day, sir, because it is not our regular.
Oh.
It's not our regular criminal docket. We have space available next Wednesday, the 12th, if you're available.
I'm going to be in trial next week. In fact, I'm going to be in trial every week between now and April 2nd.
This court would then be available on April the 16th.
Okay, that's fine, Your Honor. Is that
But
all
Mr.
right?
Noakes, I'm
Yes.
sorry.
Yes,
I was
Your
going
Honor.
to say, before we schedule the exam, there are two things I want to ask you or bring up with you. Is discovery complete in this matter?
Yes, I believe I have all the discovery. Ms. Mandernack and I've already discussed it, and if I don't have it, she'll make sure that I get it by the end of the day.
Thank you. And
Keisha,
then
I'm sorry.
I'm sorry, Ms. Mandernack, go ahead.
I'm sorry, Judge. I'm trying to get over my interrupting habit. I just wanted to confirm with the court that I have, and I confirm with Mr. Noakes, I did send him both paper and digital, but if he needs me to resend them, he can reach out.
Thank you. Mr. Noakes, the other issue that I know you're aware of, but I disclose in every single case where it could possibly be an issue, is that I'm married to an elected official in Van Buren Township. I make the disclosures, Van Buren Township is the police agency involved in this matter. My husband is not involved in the day-to-day operations of the Public Safety Department. He doesn't know anything about this case. He doesn't even know that it's scheduled. Do you need a moment to speak to Mr. Shepherd? Or are we prepared to proceed with the scheduling of the exam?
Your Honor, we're prepared to proceed. I've appeared in front of you enough that I know that you will do right by us and by the law.
I appreciate that, Mr. Noakes, but I still disclose it, so no one will ever be able to say that I didn't say it or they didn't know about it. And then we are looking at the exam date of April the 16th at what time, Marianne?
12:30.
April the 16th at 12:30 in person in courtroom number 1.
All right.
Was there anything else in this case, Ms. Mandernack?
Nothing from the people, Your Honor.
Anything else, Mr. Noakes?
Not on behalf of Mr. Shepherd. Thank you.
Then, Mr. Shepherd, that concludes this matter. April 16th at 12:30. I will see you here in courtroom number 1. Have a good afternoon.
All right, thank you, Your Honor. You too.
You're welcome. Thank you.
Your Honor, I'm sorry, I got Mason Housley and Gregory Pugh.
And Your Honor, I'm ready on Brock.
I understand that, Mr. Noakes, but give me one moment, because if
Oh,
Mr.
sure.
Housley, who's in custody, and Mr. Pugh, who is in custody, is represented by an attorney who was ready this morning, I'd rather call them so that we can get Deputy Pravanchi released from his shuffling duties for us.
Oh, that's perfectly fine, Your Honor.
But I'm not hearing a response, Deputy Pravanchi. I'm holding these files. I don't know who their attorneys are. Thank you for standing by, sir.
Yes, ma'am. Thank you.
This
Judge,
is
I'm sorry, Judge. I believe Mr. Jadal is on Gregory Pugh.
Thank you. And I saw
And I
him
feel
this
sorry
morning.
about it.
This is 241072 FY State of Michigan versus Darian Brock. Mr. Noakes, are you still with us?
Yes, I am, Your Honor.
For Mr. Brock, unmute yourself, state your name for me, sir, please.
Darian Juwan Sanchez Brock.
Thank you. Today's the Dan time scheduled for PCC. Mr. Noakes, how are we proceeding?
We're requesting an exam.
Discovery complete, sir?
Yes.
Judge, we have a 12:30 on the 16th. That will,
No, you just gave me Shepherd at 12:30.
There will be two in each time slot, Mr.
Okay.
Noakes.
Okay, this is an everybody court case.
Mr. Brock, your in-person preliminary examination is being scheduled for April the 16th, 2025 at 12:30 p.m. That will be in courtroom number 1 at 34th District Court with me, Judge Martin. Court staff will mail you notice of that new date and time. Mr. Noakes, was there anything else on behalf of your client this morning?
No, Your Honor. Thank you.
Thank you. Mr. Brock, again, April the 16th at 12:30. Have a good day, sir. You're free to go.
All right.
And
You have a better
Mr.
one.
Brock, I'll be in touch.
All right. Thank you very much. Thank you.
You're welcome.
Attorney Walred?
Good morning, Your Honor. I'm here on Kenneth Ferry, as well as Guerra and Nobles, but I only see Ferry here.
Let's start with Ferry. This is
Thank you.
250113 FD, State of Michigan versus Kenneth Ferry. May I have your names for the record, please?
Veronica
Kenneth
Walred, P85665 on behalf of Mr. Kenneth Ferry. And Mr. Ferry, can you say your name for the record?
Kenneth Ferry.
Thank you, Mr. Ferry. Today is a day and time scheduled for PCC. Attorney Walred, how are we proceeding?
Your Honor, the prosecution has just sent me digital in this matter today. This is a true third, and we need an opportunity to review it. So I would ask if the court could set another PCC out a couple of weeks so we can communicate with Mr. Bresnahan and see if there's an offer.
What's a couple?
Really, whatever you feel. If the court has availability, I know you only do Wednesdays, 19th and 26th are both open for me currently.
Do you have a preference of 2 weeks or 3 weeks is my question to you.
Oh, I don't know.
Let's give you 3 weeks. Maybe if I looked at the right month, that'd be helpful. 1, 2, 3. March the 26th at
9 o'clock with Judge Oakley.
Thank you. March the 26th for the adjourned PCC, 9 a.m. That's in courtroom number 2 in person with Chief Judge Brian Oakley.
Thank you, Your Honor.
Anything else on behalf of Mr. Ferry?
I don't believe so. Thank you.
Thank you. Sir, you're free to go. Court staff will mail you notice of that new date and time. You have a wonderful afternoon.
Thanks, you too, Your Honor.
Thank you. This is 25L026863OI, State of Michigan versus Danny's Transport. May I have your appearance, please?
Ready, Your Honor. Michael Levitt, P45336. I represent Danny's Transport.
Thank you, Mr. Levitt. The court has received an indication from the prosecutor that you have authority from your client to plead responsible to the overweight with a fine of $1,368. Was that your understanding?
Yes, it is, Your Honor, and I do have full authority on behalf of my client to plead responsible to this violation.
Thank you, sir. The court accepts the plea of responsible to the overweight, assesses the $1,368 fine in this matter. Is your client able to have that paid within the next 5 days?
Your Honor, could we get 2 weeks? Is that possible, please?
14 days to pay. Anything else this morning, sir?
No, Your Honor. Thank you very much.
Thank you. That concludes this matter. You're free to go. You have a great day.
You too.
Thank you. These are 5S44891102 A and B. These are State of Michigan versus Edward Brown Jr. May I have your appearance, sir?
Good morning, Judge. My name is Ali Hamoud. My P number is 73076. I have Mr. Brown who's sitting to my left.
Sir, state your name for me.
Edward Brown Jr.
Thank you, Mr. Brown. Today is the day and time scheduled for the arraignment, pretrial, and the pre-hearing in these matters. Mr. Hamoud, how are we proceeding?
Waive formal reading, stand mute to the charges, Judge. Seeking a pretrial about 30 days away. I believe the prosecutor didn't object to that. We're trying to get his license back.
Thank you. I don't see a bond recommendation in the file. Mr. Hamoud, any comment regarding bond?
Judge, my client's 51 years old. He doesn't have much of a record. This is most of the cases that he's got is driving related. I do believe a personal bond is appropriate in this case.
Absolutely. Mr. Brown, the court will set your bond at $3,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by the court until the case is resolved in its entirety. Let's put this over 1, 2, 3, 4 weeks puts us on April the 2nd.
At 9:45 with Judge Patton.
Thank you. At 9:45, and that will be in courtroom number 3 by Zoom with Judge Patton. Notice of that new date and time will be sent out to you April the 2nd, 9:45 by Zoom with Judge Patton. Mr. Hamoud, was there anything else on behalf of your client this morning?
No, Your Honor, thank you very much. Have a great day to you and your staff.
Thank you. You too. Have a good day, Mr. Brown, and good luck to you.
Yes, ma'am. Thank you. You as well.
Thank you. I know, Pravanchi, I feel the same way.
Your Honor, we may have to disconnect. We were backing up with the courts, but have Mary Ann text me when you guys are ready.
I appreciate you. Thank you, sir.
excuse me, I'm sorry, Marianne or Judge. I only have Gregory Pugh left with you today for pretrial. I spoke with Mr. Drajala. He's in custody, so I think we're waiting for the jail to come back. I'm gonna go dark and make a couple phone calls if that's okay.
Absolutely.
Okay, thank you. And then I know you guys have my cell phone number, both my cell phone numbers, if I don't come back.
Thank you,
in
ma'am.
time. Thank you, Judge.
Marianne, I'm stepping off for 1 second to get to the bottom of what I asked you to reach out about.
Madam Clerk, I just wanted you to know I was here. Marianne, I wanted you to know I was here.
Thank you.
Hi, good morning, Mr. Stacy. Do you need to speak with the prosecutor?
I don't believe so. No, we were gonna set it for an exam. We can set it out a little ways.
Okay,
My
thank
client
you.
would waive the 21-day rule.
Okay, thanks. The judge will be right out.
You have right there. There's a- the next two. So you have a right there.
Be nice. Hey, no.
Mr. Jadala, your ears must have been ringing. We were just trying to figure out if we needed to get Mr. Pugh on, or did you have something else that, oh, I see you have something else ready.
I have 2 matters ready, Your Honor, and then whenever Mr. Pugh is ready, I'll talk with Mr. Pugh.
Marianne is reaching out to get the jail back on if we possibly can. I have 1 felony matter that I need to tend to, and then I will call Mr. Hitchcock and Mr. Doman. I'm sorry, Ms. Doman. 241024 FY, State of Michigan versus Adam Gillikin. May I have your appearance, please?
Good morning, Your Honor. For the record, Brian Stacy on behalf of Adam Milliken, and please state your name.
Adam Gillikin.
Thank you. Today was the day and time scheduled for PCC in this matter. Mr. Stacy, how are we proceeding?
Judge, at this time, I've had an opportunity to speak with my client. He understands he has the right to have this matter heard within 21 days. He's going to give up the opportunity to do that. So I can have an ability to go over discovery. There might be some missing discovery too. So my client believes that there's a video that, and this is my first day on the case, and I haven't gone over everything or anything practically. And so I didn't know if the court wanted to set it for a preliminary exam, or if we have a motion about discovery, should I set it on the exam date, or should we set it out to like March 26th for a motion PCC?
March the 26th, this court is not on the criminal docket. We'll be off of the criminal docket until April the 16th. Mr.
Okay.
Stacy, just so you know, when the parties were here back on December the 12th, there was conversation regarding a missing audio and video, an unredacted police report, and an anonymous witness interview by Hernandez. So those discovery issues have been raised previously by Mr. Head back on December the 18th, 2024. I'm just letting you know so that we're all on the same page. If you want to do a motion date, we'll schedule it motion exam on the April the 16th, unless there's some different way you want to proceed this.
No, that's
case.
fine, Judge. If you want to combine them like that, that's absolutely fine.
It's not a question of want or don't want. We can just schedule it for exam on for motion on the 16th. You tell me how you wish to proceed, sir.
No, Judge, I think my client's anxious to have this case move forward. So if we could do the exam and motion on the 16th, that would be marvelous.
And before Mary Ann gives us a time, Mr. Stacy, I want to disclose to you on the record that I'm married to an elected official in Van Buren Township. I make the disclosures. Van Buren Township is the police agency involved in the investigation of this case. My husband is not involved in the day-to-day operations of the Public Safety Department. He doesn't know anything about this case. He doesn't even know that it's scheduled. That disclosure having been made, do you need a moment to confer with Mr. Gillikin, or are you prepared to proceed with the scheduling of the exam?
Well, Judge, I do know for a fact that the alleged victims are both one's on the commission, the woman Stacy, she's on the Van Buren commission, I forget which commission, and then her husband Kevin is an elected,
He was a formal elected official on the Board of Education.
Okay. So yeah, he's on the Board of Education for Van Buren. So and since there's the victims are Van Buren, and my client obviously is from Van Buren, I would think that I don't know, Judge, I think my client would feel more comfortable perhaps if we were able to go with another judge, even though I have all the confidence in the world with
No,
you. I'm just
Mr. Stacy, no worries. What I'll do is I'll put this matter over to Judge Oakley's docket on March the 19th.
Yes, at 9 o'clock, Judge.
wait a second. I have a oh yeah, all right, the 19th, yes. What time would that be at?
9 o'clock.
Is that a Zoom?
No, that will be in person. March the 19th at 9 a.m. And Mr. Stacy, as I indicated, you have an absolute right to have this case assigned to another judge, but I will disclose to you on the record, I don't know the victim. I don't know her husband. I don't know any of the other people involved in this case, just so the record's clear. But the case is scheduled for PCC in courtroom number 2 in person with Chief Judge Brian Oakley, March 19th, 9 a.m. Was there anything else on behalf of your client?
No, Your Honor. And again, I just know I have again all the Judge, there is the issue of bond. My client has been removed from the home since November of 17th. He has a 4.5-year-old child and his wife, and she has to commute back to the home 30 miles one way to feed they have 10 cats and 3 chickens. And my client's never been in trouble before, and he recently had a very regrettable, his 5-month-old premature daughter passed away on January 3rd. So there's been a lot of upheaval in his life. It's been very traumatic. And I would respectfully ask the court to modify the bond conditions. He is on a GPS tether, which
Mr. Stacy, this court is not going to modify the bond without the prosecutor in the courtroom. If you want to wait for Mr. Mohammed to come out, I'm happy to take that up with him.
Okay, we'll wait, Judge.
Okay, then I'll put the file and we'll wait for him to come from the breakout room. Thank you, sir. This is 250108 SD. This is State of Michigan versus Autumn Doman. May I have your names for the record, please?
Autumn Christine Doman.
And Your Honor, respectfully, Sam Richardall, 62186, appearing on behalf of Ms. Doman. Your Honor, for purpose of today's pretrial, I've had the opportunity to speak with the city attorney as well as my client. My client's going to be tendering a plea today to 1 count of operating while intoxicated, count 1, high BAC, and count 3, operating while intoxicated with the occupant under 16 are being dismissed pursuant to the plea, Judge.
I'm sorry, Mr. Jadala, you have to say that again.
Sure. Your Honor, my client will be pleading to count 2, operating while intoxicated, count 1, operating with a high BAC, and count 3, operating while intoxicated with an occupant less than 16 is being dismissed.
Thank you. And Mr. Jadala, before I take this plea from your client, I want to disclose on the record that I'm married to an elected official in Van Buren Township. I make that disclosure as Van Buren Township is the police agency involved in this matter. My husband is not involved in the day-to-day operations of the Public Safety Department. He doesn't know anything about this case. He doesn't even know that it's scheduled. That disclosure having been made, do you need a moment to speak with your client, or are you prepared to proceed with the plea?
Your Honor, we are both prepared to proceed with the plea, Your Honor.
Ms. Doman, would you raise your right hand for me, please, ma'am? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may put your hand down. You've had the opportunity to discuss this case with Mr. Jadala, and you understand the charges you face and the possible penalties.
Yes, ma'am.
And after having that conversation, is it your understanding and agreement that you will be entering a plea of guilty this morning to count 2, operating while intoxicated?
Yes, ma'am.
And you understand that if the court accepts your plea this morning, you will not have a trial of any kind?
Yes, ma'am.
You will not have the opportunity to present witnesses on your own behalf or see cross-examine witnesses put forth by the prosecutor?
Yes, ma'am.
And you're entering this plea freely and voluntarily?
Yes, ma'am.
You haven't been threatened in any way or promised anything to get you to plead guilty?
No, ma'am.
Are you pleading guilty because you are in fact guilty?
Yes, ma'am.
Ma'am, is it true that on January 30th, 2025 in Van Buren Township, you operated a motor vehicle while you were intoxicated?
Yes, ma'am.
Before operating a vehicle, you had ingested something that affected your ability to operate that vehicle safely?
Yes, ma'am.
Mr. Jadala, would you like to inquire further of your client? You're muted, sir.
I'm sorry, Judge, I'm satisfied, Your Honor.
Thank you. Ma'am, the court accepts your plea of guilty to count 2, operating while intoxicated, and will dismiss count 1 and count 3. Because this is a drinking and driving offense, you will be referred to the court's probation department. This court's agent, Mr. Tony Grant, will be in contact with you by phone and by email. There will be forms for you to complete and an interview for you to submit to. Once you've had the opportunity to speak to Mr. Grant, he will write a recommendation regarding sentencing and schedule you to return to this courtroom for sentence to be imposed, okay?
Yes, ma'am.
Anything else in this matter this morning, Mr. Jadala?
Nothing further, Judge.
Thank you. Ms. Doman, you're free to go. I will see you at sentencing. Good luck to you.
Thank you.
You're welcome. Yes, sir.
Thomas Jones. Thank you.
This is 201094 SD, State of Michigan versus Harold Haycock. May I have your names, please?
Your Honor, respectfully, Sam Richardala, appearing on behalf of Mr. Haycock. Mr. Haycock, please say your name for the record.
Harold Haycock Jr.
Thank you, sir. Today is the day and time scheduled for the pretrial. Mr. Jadala, how are we proceeding?
Your Honor, today's the day and time set for a pretrial. Your Honor, I've spoke with the state prosecutor. He has CC'd me on an email with the appropriate officials. Your Honor, we've made numerous attempts to receive discovery. We have not received either paper or digital. The state prosecutor, we are just asking for one more pretrial. And at that time, Your Honor, failure to provide any type of discovery will lead to me making a motion for dismissal. Prosecutor does understand that. So I guess, Your Honor, to make a long story short, we just asked for another pretrial date, Judge, please.
How far out, Mr. Jadala? Mr. Jadala?
When's the court's next docket, Judge?
Next Wednesday, every Wednesday, you know that.
Yes. For the state case. So you're here next Wednesday?
Every single Wednesday.
Yeah, just to be fair to the prosecution, I know my client needs this done fairly quickly. If we could have next week, Your Honor, that would be great.
At 10:15.
March the 12th at 10:15. Back here on Zoom with me, Mr. Haycock, in courtroom number 1. Last adjournment for discovery.
Thank you, Judge.
Anything else, Mr. Jadala?
Nothing further, Your Honor.
Thank you. Sir, thank you for your patience. You're free to go. When you're here next week, I expect you not to have a cap on for me, please.
Yes, ma'am.
Thank you. 230967 SM. This is State of Michigan versus Stephen Schmitling. Mr. Schmitling? I see his phone out in the breakout room, in the waiting room. I need, thank you. Mr. Schmitling? Mr. Schmitling?
Yes, ma'am. Can you hear me?
I can hear you now, sir. State your name for me, please.
Stephen Schmitling.
Thank you. Sir, this case was scheduled because you had failed to appear. Your bond had been forfeit, but you're present now. Did you speak to someone this morning?
Yes, ma'am, I did.
Was
Last
it
time
Was it Mr. Jadala?
Yes, it was.
Okay, he's here. When he comes back out, we'll pick up your case again.
Okay.
I just need a
yeah.
moment to, okay.
Okay, last time I had trouble getting on the Zoom and it kept kicking me off.
I know. I have notes in there that you have been present and then you weren't when the case was called, but we'll get Mr. Jadala back out in just one moment. Sit tight for me. Mr. Jones?
Okay, thank you.
This is 25W023905SM. This is State of Michigan versus Thomas Jones. State your name for me, sir.
Joe.
How are you this morning? I have a note from the prosecutor that this case is to be dismissed. Is that your understanding? Case is dismissed. Is there anything else you need this morning?
Okay.
Have a great day. You're free to go. Would you let Mr. Mohammed know that I need him for a second, please? No, he can, yeah, please and thank you. Two 50054 FY, State of Michigan versus Rebecca Reynolds. May I have your appearances?
Good morning. If it may please the court, Sarah Robinson, P63181 for Miss Rebecca Reynolds. Miss Reynolds, please state your name for the record.
Hi, Rebecca Reynolds.
Thank you, Ms. Reynolds. Today is the day and time scheduled for the PCC. Ms. Robinson, how are we proceeding?
Your Honor, I've conferred with the prosecutor, Mr. Mohammed. We are still negotiating. This is a stipulation to adjourn the PCC for 3 weeks, please.
Absolutely. Give me 1 second so we get a time for you.
Thank you, Your Honor.
9 o'clock, Judge.
March the 26th at 9 a.m. And that will be in person in courtroom number 2 with Chief Judge Brian Oakley. Was there anything else this morning, Ms. Robinson?
No, Your Honor.
Then Ms. Reynolds, that concludes this matter. Ma'am, you're free to go. You have a great afternoon.
Thank you. You as well.
Thank you. This is a recall of 241024 FY. This was State of Michigan versus Gillikin. Mr.
Good morning, Your
Mohammed.
Honor. Mohammed on behalf of the people.
And again, Your Honor, for the record, Brian Stacy with Mr. Gillikin on his behalf.
Thank you. Mr. Mohammed, I ask that you come into the courtroom because Mr. Stacy, the court disclosed the relationship with Van Buren Township. Mr. Stacy asked that this case be reassigned. The case is being adjourned over to March the 19th at 9 a.m. with Judge Oakley. Mr. Stacy wanted to address bond. I thought it appropriate that you be in the courtroom for that conversation. Mr. Stacy.
Thank you very much, Judge, for this opportunity. My client is an older gentleman. He's married with a 4.5-year-old. He's never been in trouble before. This alleged incident happened to these alleged victims. It involves an unloaded pellet gun, and he's been removed from his house. So his wife and 4.5-year-old left with him. His 5-month-old daughter died on January 3rd from complications, and he has 10 cats and 3 chickens that his wife has to drive 30 miles one way to feed every day. He's never been in problem. He never even had an opportunity to get his possessions back from the home. So, Judge, quite frankly, in 45 years, I've never seen a case where a man and his family were removed from the home over an unloaded pellet gun. And this is, I think, excessive. He is on a GPS tether, so that keeps track of every step of the way. They can always backtrack it and find out exactly where he was standing at any given time. So with the fact that he's on a GPS tether, the fact he's never been in trouble before, the fact that nobody was threatened personally, this involves an incident that it occurs almost 300 feet away from the alleged victim's home. And quite frankly, I just think that it's very excessive that he's not able to go back to his own home, considering everything that's going on with him, his wife, his 4.5-year-old, and the fact that he lost his daughter last month. And this is it's very, very difficult on him. And I respectfully ask, since he is on GPS tether, to let him back into his home.
Mr. Mohammed.
Judge, as I mentioned before, this might be the defendant's 4th or 5th attorney. I've lost count at this point. The bond conditions in this case are not just based off of, it's based off of the defendant's prior history with the police, as there was been over 20 calls to his residence, but also the fact in this case is not just something as someone pointing a pneumatic weapon at a person, but also like the fact in this case is that the defendant exhibited erratic behavior, speaking about conspiracies, hijacking of his devices, made statements about repeated break-ins, issues with his alarm system, electronics. So we believe there's a mental aspect to this case. There was an emergency order signed by a judge where there was a confiscation of the defendant's firearms, which I believe was something around the number of 15 guns were recovered from the defendant. Also, previously, this defendant was ordered by the court multiple times to have a mental evaluation treatment done and to respond and give us an update on that. And as of today's date, I don't think that's been done. And so I'm going to object. I think there's a lot of concerns with the specific defendant and his behavior. And so in the interest of the protection of the victims, I'm going to request that the bond remained as is based off of the surrounding circumstances, respectfully. Thank you. And also, just for clarity, the defendant's family was never removed from the home. There's no issues with the defendant's family returning to that location. My understanding, based off of discussions with the victims and members of the victim, is that there might be some other issues between the defendant and his wife or something of that nature. But I don't have personal knowledge, so I won't speculate. But in regards to whether or not his family can return, of course they can return. And again, my condolences are with the defendant regarding the loss of his child.
Judge, briefly, in response, no calls were ever made involving any type of criminal activity. No gun was ever pointed at an individual. The individual allegedly was standing in their house, which was 262 feet away. And my client is looking for squirrels because they ate up his air conditioning unit with the scope. He doesn't have a pair of binoculars, so he was using the scope on his pellet gun that was unloaded. And they even said he was pointing to different places. When they show up that day, there's loud banging. The loud banging ended up being him shooting hockey. He plays hockey.
Mr. Stacy, I'm interrupting you because I don't know that we want to start going down the path of the facts of what happened on the day and time.
Well,
Mr. Mohammed raised an issue that when and I don't know if you have gone through the history of this, when Mr. Gillikin was arraigned back on November the 19th, the bond was set at $30,000 cash or surety with GPS tether and no contact with Stacy English. Appeared in front of Judge Green on November the 27th, at which time Judge Green modified the bond, no entry within 5 miles of the home, mental health evaluation, and she set a curfew from 8 a.m. to 9 p.m. He appeared before this court on December 18th, and the court declined to modify the bond because the condition of the mental health evaluation had not been met. And there were some concerns raised about the number of guns at the home, and the court did refer the matter to pretrial services for bond review. Pretrial services deferred review recommendation on bond because Mr. Gillikin was out and was on GPS tether. So my specific directed question to you is, did he have the mental health evaluation ordered by Judge Green back on November 27, 2024?
Your Honor, I have in front of me, which I'm happy to scan and email to the court and to the prosecutor, Mr. Mohammed, who I've dealt with before, and we've always had a good working relationship. One is dated January 16th, and the other one is dated March 4th of 2025, so it was very recent. And they both indicate that he's receiving counseling and psychotherapy services. He's compliant with treatment, and feel free to call us if you have any concerns. And that's basically the same letter that since October of 2023, he's been receiving bi-monthly counseling and services, and he's compliant with all treatment. Feel free to contact us for additional information. And that one's dated March 4th. So he is going on a bi-monthly basis to what's called America Substance Abuse, Behavioral, and Mental Health. The letters that indicated, I wouldn't necessarily call them mental evaluations, but he's clearly compliant when he's doing his therapy. But I can instruct him to have something more directed more specifically for the hearing in front of Judge Oakley on the 19th. But the judge, he is in counseling, and he has been going to counseling since October of 23.
Mr. Stacy, that information is not, I don't see it in the court file. The court is going to deny your request to modify the bond at this time. I would suggest that you send that information over to Judge Oakley's courtroom so that it's in the file, that Judge Oakley has the opportunity to review it. You've asked that the case be reassigned. It is in fact reassigned. Judge Oakley will take up the argument further if you wish regarding bond on March the 19th at 9 a.m. That concludes this matter. Good luck to you.
Judge, can I have Judge Oakley's email address?
Marianne will put Heather's email address. Heather is Judge Oakley's secretary. She'll put her email address in the chat to you if you want to take that down, or she can take you into a breakout room and go over it with you.
Well, thank you very much, Marianne.
Mr. Nunley, did you speak with Mr. Schmitling?
I did, Your Honor. I am ready to proceed.
This is 230967 SM. This is State of Michigan versus Stephen Schmittling. May I have your appearances?
Royce Nunley appearing on behalf of the defendant. Mr. Schmittling, would you please state your full name for the record?
Stephen Schmittling.
Thank you.
yeah.
Mr. Nunley, this case is in warrant status. The court is recalling the warrant. How are we proceeding?
Yeah, so I noticed it was in show cause status, and I checked the register of actions, and at his last court date, which I believe was in maybe January, the end of January, the ROA indicates that he was present at some point, that maybe there was some connectivity problems, and that the court lost him, or he lost the court, one of the two. He did call immediately to take care of it. We're here today. We're ready to proceed at this time if the court would allow.
Absolutely.
Yeah, and regarding the pretrial judge, so the incident date on this one is something. It is
June of 21.
Yeah, June of 21. The complaint issued in the end of December of 23. I asked that Mr. Mohammed send me the discovery in this case, which he did already. I have it. So I'm just asking for a date, maybe 3 to 4 weeks out, so that I can draft a motion and file with the court.
Thank you. Mr. Schmittling's bond in the interim will be set at $5,000 personal. Mr. Schmittling, you don't need to post any money, but what you must do is appear as directed by this court until this case is resolved in its entirety. Mr. Nunley, it will actually be more than 4 weeks. It will actually be April the 16th if you're available.
April the 16th. Yeah, I would, as long as it's before 11 a.m., I would be available.
April the 16th, how early, Marianne?
9 o'clock.
9 a.m.
Perfect.
Mr. Nunley, the note I'm writing is that it is adjourned pretrial motion. I'm guessing speedy trial motion.
Correct.
I'll take it up with you on April the 16th at 9 a.m. unless there's anything further.
Nothing further, Judge. Thank you.
Mr. Schmittling, thank you so much for your patience this morning, sir. I will see you in April. You have a wonderful afternoon.
Yes, ma'am. Thank you so much.
You're so welcome. Ms. Greer, this is 5S4473150ST, State of Michigan versus Valeria Greer. May I have your names for the record, please?
Royce Nunley appearing on behalf of the defendant. Ms. Greer, would you state your full name for the record?
You're muted, ma'am.
Yeah, just unmute.
Okay, can you hear me now?
Yes, ma'am.
Okay, Valeria Greer.
Thank you, Ms. Greer. Today is the day and time scheduled for the arraignment and pretrial. Mr. Nunley, how are we proceeding?
For purposes of the arraignment, we'd waive a formal reading and ask the court to enter plea of not guilty. For purposes of the pretrial, she's going to accept the offer of the reduced charge of allowing an unlicensed driver to drive.
I'm sorry, the reduced of?
Allowing.
Okay, thank you.
Mhm.
Ms. Greer, would you raise your right hand for me, please, ma'am? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may put your hand down. You've had the opportunity to discuss this case with Mr. Nunley, and you understand the charges you face and the possible penalties.
I do.
And after having that conversation, ma'am, is it your understanding and agreement that you will be entering a plea of guilty this morning to the reduced count of allowing an unlicensed driver to drive?
Yes.
And you understand that if the court accepts your plea this morning, you will not have a trial of any kind?
That's correct.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor?
Yes,
And ma'am, you're entering this plea freely and voluntarily?
I am.
You haven't been threatened in any way or promised anything to get you to plead guilty?
No, I haven't.
Are you pleading guilty because you are in fact guilty?
Yes,
Ma'am, is it true that on February 11, 2025, Michigan State Police found you in the city of Romulus allowing an unlicensed driver to drive?
yes,
Satisfied, Mr. Nunley?
Satisfied, Judge.
Ma'am, the court accepts your plea of guilty to the reduced count of allowing an unlicensed driver to drive. Mr. Nunley, anything before fines and costs are imposed in this matter?
I'd ask the court to consider a lower fine for Ms. Greer. She has never had a driving issue ever. the reason that her little license snafu happened is she cut a check to the Secretary of State, which ended up bouncing, which she didn't even know. She got pulled over on February 11th. She held up a receipt and showed me that she went to the Secretary of State on February 12th, and she rectified the situation. So this is the only snafu that she has ever had with her license, and it lasts, the minute that she found out, it was 24 hours and she had it taken care of. So it's an unfortunate situation, but she is about to have surgery, which means she's going to be going on short-term disability. So while she's on short-term disability, she's obviously only going to be making a fraction of her income, and bills will be tight for her.
When you say lower amount, what do you mean by lower amount?
Whatever the court is able to do. I know that the fines and costs are, to a certain extent in the discretion of the court. If the court would be inclined to waive any fees or fines, then I know that Ms. Greer would be greatly appreciative. And I do not believe that you will be seeing Ms. Greer back in front of you for any issue whatsoever. I would imagine.
Mr. Nunley, the court appreciates your advocacy, and the court does not the court will impose minimal fines and costs in this matter, will not waive the fines and costs, but will set them at $100 fine, $100 in cost, $75 mandatory crime victims fee, $50 mandatory state costs, and $20 fund fee. That's $345. Ms. Greer, if you need time to make payment on that amount, you're free to do so by contacting the court's collection department. But are you able to pay the $345 within the next 5 days?
No.
Then I'll have you contact the court's collections department. You're able to do that in one of three ways. You may come in person and speak to someone. You may call and speak to someone in collections, or you can go onto the court's website. There's a contact us button. If you click on that button, the drop down will allow you to submit an email request for a payment plan. But please do one of those three things sooner rather than later, okay?
Okay.
Then, ma'am, other than that, you're free to go. You have a great afternoon. Good luck to you.
Okay. You too. Thank you so much.
You're so welcome. This is 5S4480862ST. This is State of Michigan versus Richard Allen. I note your appearance, Mr. Nunley. Mr. Allen, unmute yourself, turn your video on, state your name for me, please.
Good morning. My name is Richard Allen.
Good morning, Mr. Allen. Today is the day and time scheduled for your adjourned pretrial. Mr. Nunley, how are we proceeding?
At this time, Mr. Allen will be pleading guilty to the reduced charge of no operating license on person.
Mr. Allen, raise your right hand for me, please, sir. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may put your hand down. Sir, you've had the opportunity to discuss this case with Mr. Nunley. You understand the charges you face and the possible penalties.
Yes.
And after having that conversation, sir, is it your understanding and agreement that you'll be entering a plea of guilty this morning to the reduced count of no operator's license on person?
Yes.
And you understand that if the court accepts your plea this morning, you will not have a trial of any kind?
Correct. Yes.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
I understand.
And sir, you're entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way or promised anything to get you to plead guilty?
No.
Are you pleading guilty because you are in fact guilty?
Yes.
Mr. Allen, is it true that on January 6, 2025, Michigan State Police found you in Huron Township operating a motor vehicle without an operator's license on your person?
Correct.
Satisfied, Mr. Nunley?
Satisfied, Judge.
Mr. Allen, the court accepts your plea of guilty to no operator's license on person. Will dismiss the original charge of operating without a license. That's a weird one. Anything before fines and costs are imposed, Mr. Nunley?
Just for the court's knowledge, Mr. Allen is in the process of getting his license back. He has to do one of those Secretary of State hearings where he goes before the Secretary of State, and I tried to warn him that those can be tough and what to expect. But he has submitted all of his paperwork, and he's just waiting for that hearing. So he hopes to be back on the road legally driving, sooner than later, hopefully.
Mr. Allen, the court will impose the following: a fine of $100, cost of $100. There's $75 mandatory crime victims fee. There's $50 mandatory state costs, $20 fund fee, that's $345. Do you need more than 5 days to pay that amount, sir?
Actually, well, a little bit more than 5 days. I can't pay it this Friday, but the following Friday, which I think is like the 14th, I'll be able to pay that in full.
So I'll say 14 days to pay. If you get in sooner, great. Otherwise, let's say within that 14 days, okay?
Okay, sounds great. Thank you, Your Honor.
If there's nothing else, Mr. Allen, you're free to go. You have a wonderful afternoon. Thank you for your
You too.
patience today.
Thank you. Bye-bye.
This is 250180 SM. This is State of Michigan versus James Macheski.
Good
State
morning,
your
Your
name for
Honor.
me, please, sir.
James Edward Chesky, Your Honor.
Thank you, sir. Today is the day and time scheduled for pretrial on this matter. Mr. Nunley, how are we proceeding?
We'd be just asking for an adjournment. I have requested the discovery from Mr. Mohammed. I believe that there's an email in my inbox now with the discovery, so we just need some time to review it and decide how. Oh, I'm sorry, and that's actually not exactly correct. We also are asking for it to be set for a final pretrial where the victim must appear.
How far out, Mr. Nunley?
A couple weeks.
1, 2, 3 weeks?
Any of all of the above, any and all of the above. Whenever the
Let's
court
say
is
two.
ready to run.
Let's say 2 weeks, which will put us on March the 19th.
Perfect.
At 9:15.
Perfect.
March 19th at 9:15 a.m. That will be in number 2 in person with Judge Oakley.
Okay, in person. Got it.
Complainant to appear. Was there anything else, Mr. Nunley?
Nothing further, Judge. Thank you.
Thank you. Mr. Macheski, court staff will mail you notice of the new date and time, that March 19th at 9:15 in number 2 with Judge Oakley. You're free to go, sir. You have a great afternoon.
Thank you, ma'am. You as well.
Thank you. Thanks, sir. Mr. DiMaggio, who are you with? No? Okay, we'll try something different. Are we ready with Mr. Mickle?
Good morning, Your Honor. R. Thomas Bedard on behalf of Mr. Mickle, who is also, I believe, logging in.
I'm sorry, I was asking, were you ready? So the answer is yes. Let me call the 24LH00006 A and B. This is State of Michigan versus Chad Mickle. Mr. Mickle, your name for me, please, sir.
Chad Mickle.
Thank you. Today is a day and time scheduled for the pretrial and pre-hearing. Mr. Bedard, how are we proceeding this morning?
Unfortunately, we could not resolve it today, so we are asking for a bench trial, non-jury trial. I advise Mr. Mickle of his rights to hold a jury trial in this matter, and he wishes to waive that and proceed with a bench trial. But again, it's our hopes that that may not be necessary with our ongoing attempts to resolve this.
Mr. Mickle, was that your understanding of how we were proceeding this morning?
Yes, ma'am.
You're waiving your right to have a jury trial.
Correct.
We'll schedule the bench trial for,
Judge, you have an 11:15 next Wednesday on the 12th. Or April 16th at 11.
Your Honor, if we may, April 16th would work better with my schedule.
absolutely. Mr. Mickle, your in-person bench trial with me will be on Wednesday, April the 16th at 11 a.m. I'm in courtroom number 1 at the 34th District Court. Court staff will mail you notice of that new date and time. Was there anything else on behalf of your client, sir?
No, Your Honor, thank you so much.
You're so very welcome. Mr. Mickle, you're free to go. You have a wonderful afternoon, sir.
Thank you, Your Honor.
These are 25L026908 AMV. State of Michigan versus Republic Company. May I have your appearance, sir?
Good morning, Your Honor. May it please the court, Michael Sherbo appearing on behalf of corporate defendant Republic Company.
Mr. Sherbo, today is the day and time scheduled for pre-hearing in this matter. The court has received from the prosecutor an indication that you have authority from your client to enter a plea of responsible to overweight with a fine of $877 and a plea of responsible to equipment violation with a fine of $140. Was that your understanding and agreement?
That is correct, Your Honor.
The court accepts the pleas of responsible on behalf of your client as indicated. There will be a fine of $877 for the overweight and $140 for the equipment violation. That's $1,017. Does your client need more than 5 days to pay that amount?
Yes, Your Honor. If we could we have 30 days to pay?
14 days is more in my wheelhouse. Do you think your client can do that?
We'll make it work. Thank you, Your Honor.
14 days to pay. Anything else this morning, sir?
No, thank you, Your Honor.
Thank you. Have a great day.
You too.
Mr. Reeves, we're just waiting for Mr. Martin to appear. Did he ask you to log on early this morning?
Yes, ma'am.
Okay, as soon as I see Mr. Martin. Thank you. Mr. Daggio, second call, sir. Oh, Marianne. Marianne, I'm sorry. Nickel. I didn't know. It came in after.
Damaggio's here.
I'm sorry, sir. I was trying to get your attention before. What are you here for?
A Mason Housley.
Oh, Mr. Housley is in custody. The jail had logged off. We can try to get him back on. Is he with you by chance? Or, excuse me, I just
No,
said he's in jail.
custody.
Have you spoken to him?
Yes.
Give me one moment to see if Marianne will be able to get the jail back on with him.
Yeah, Judge, I sent the deputy a text message 42 minutes ago and I still haven't had a reply.
Mr. DiMaggio, they've been backed up this morning and they have been on for maybe 2 hours with us. If you want to, we can adjourn this matter over for a week.
Yeah, that would be good because I want to discuss this current case he's got too. So a week would be good.
This is 250007 SD. This is State of Michigan versus Mason Housley. May I have your formal appearance, sir?
Andrew DiMaggio, P45619 on behalf of Mason Housley.
And again, this case was scheduled this morning for arraignment pretrial at 9:45. It's 10:46. The court has made efforts to get the jail back on. We have been unsuccessful. The court will adjourn this matter over till next Wednesday, March the 12th at 8:30 a.m.
Okay.
And we'll get the jail back on at that time. Was there anything else this morning, Mr. DiMaggio?
Yes, I neglected to ask the prosecutor for the discovery. Is it possible I could be put in the breakout room with him?
Absolutely. We'll get you moved back into the breakout room with him.
Thank you, Judge.
You're very welcome. Give me 1 second, Mr. Jadala.
Absolutely, Judge.
Good morning. This is Judge Martin. How may I help you? I'm good. Do you swear or affirm the contents of the affidavit are true to the best of your knowledge, information, and belief? Send it over for me, please. Thank you. Bye-bye. Two four one one nine one SM, State of Michigan versus Patrick Allen. May I have your names for the record, please?
Your Honor, respectfully, Sam Jadala, P62186, appearing on behalf of Mr. Allen. Mr. Allen, if you'd say your name for the record, please.
Good morning, Patrick Allen.
Thank you, Mr. Allen. Today is the day and time scheduled for pretrial in this matter. Mr. Jadala, how are we proceeding?
Your Honor, at this time, Mr. Allen will be pleading guilty to one count of disorderly conduct. This matter will be taken under advisement for a period of 12 months under 771.1. Part of the plea, Your Honor, is anger management and better decision-making program. My client understands the rights that he is waiving by taking this plea, and he wishes to avail himself to it. Is that correct, Mr. Allen?
That is correct.
Mr. Allen, would you raise your right hand for me, please, sir? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir. You may put your hand down. You've had the opportunity to discuss this case with Mr. Jadala, and you understand the charges you face and the possible penalties.
Yes, I do.
And after having that conversation, sir, is it your understanding and agreement that you will be pleading guilty this morning to the added count of being a disorderly person and that the original charge will be dismissed?
Yes, it is.
And you understand that if the court accepts your plea this morning, you will not have a trial of any kind?
Yes, I do.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor?
I understand that. Yes.
And sir, you're entering this plea freely and voluntarily?
Yes, I am.
You haven't been threatened in any way or promised anything to get you to plead guilty?
No, I have not.
Are you pleading guilty because you are in fact guilty?
I believe I am in fact guilty of the, yes.
Mr. Allen, I'm sorry. Is it true that on August the 21st, 2024, in the city of Romulus, you were a disorderly person?
Yes.
Mr. Jadala, do you want to inquire further of your client?
No, Your Honor, I'm satisfied with that.
Mr. Allen, the court will accept your plea of guilty to being a disorderly person. As indicated by Mr. Jadala, your plea is being taken pursuant to MCL 771.1 for a period of 12 months. Sir, so long as you pay costs to the court of $300, complete the anger management, better decision-making, and incur no new criminal offenses in the state of Michigan for the next 12 months, your case will be administratively reviewed for dismissal. Was there anything else, Mr. Jadala?
Nothing further, Judge. Thank you.
Was there anything else, Mr. Allen?
No.
Then, Mr. Allen, that concludes this matter. Sir, you're free to go. If you need to make a payment plan, you may stop at the court's cashier's counter and make that payment plan, or if you're able to pay the $300 in full this morning, you can do that as well.
Understood.
Thank you, sir. Have a good day.
Thank you.
Your Honor, I don't mean to interrupt. Was there any updates on Mr. Pugh from the jail?
Mary Ann had reached back out to them about 50 minutes ago now and had not received a response. And that's on the court. That's not on you, and that's not on Mr. Pugh. So you tell me how you wish to proceed this morning. We're talking about 250062 SM, State of Michigan versus Gregory Pugh.
Your Honor, respectfully, Sam Jadala, P62186, appearing on behalf of Mr. Pugh. Your Honor, I did speak to APA Ms. Mandernack, and she let me know what we were both intending is to adjourn this matter. It looks like they have a felony matter with the same alleged victim that has been bound over to circuit court with the calendar conference not into March 11th. And there was going to be hopefully try to seek a global resolution. So if we can have a date after March 11th, Your Honor, and hopefully we'll be able to come to a resolution. Maybe I'm here on the 12th for Mr. Haycock. Perhaps on the 12th, we'd have an update for Mr. Pugh.
I was going to suggest that because I'm back on that docket on March the 12th at
It'll be 8:30, Judge.
okay. Oh, sorry.
Um,
March.
Yeah, I'm sorry, just 1 minute ago, deputy said that they're still waiting for, a camera, so.
Then wave him off. We'll put Mr. Jadala over till next week at 8:30 a.m. on Zoom with me here in courtroom number 1. Mr. Jadala, Mr. Pugh has another issue. He has 2 cases in warrant status out of Belleville for resisting arrest and for driving while license suspended. These are from the driving while license suspended is from February 3rd of 2024. And the resisting arrest is from January 16th, 2025. Again, they're both city of Belleville. But when Mr. Pugh logs on next Wednesday, we'll take up those 2 matters just to get them back on track on the local docket. I'll recall the warrant next week when he's actually appearing on camera, okay?
Understood, Judge.
Was there anything else this morning?
No, no, ma'am. Thank you so much.
You're so very welcome. There's 250039 SD. This is State of Michigan versus Trishan Delco Palmer. This case was scheduled for show cause arraignment pretrial at 8 a.m. It is now 10:54 by this court's clock. Defendants failed to appear. Bench warrant shall issue 5,010%. Two 250032 SD, State of Michigan versus Tricia Hollingsworth. This case was scheduled for show cause arraignment pretrial at 8 a.m. It's now 10:55 by this court's clock. Defendant having failed to appear, bench warrant shall issue 5,010%. Yes, Mr. Jadala.
Your Honor, I also had a Mrs. Massey, Lamika Massey, scheduled at 10:15. She was in custody on the 19th. Last time we talked, I'm not sure if she's appeared at all.
I have not seen her. I don't see any unidentified persons in our breakouts. You're referring to 2501119 SM. This was State of Michigan versus Lamika Massey.
That is correct, Your Honor.
Case was scheduled at 11:15, excuse me, 10:15. It's now 10:57 by this court's clock.
And at this time, I have no reason for a non-appearance.
It was scheduled for final pretrial. I don't see witnesses either.
Correct. Your
Schedule the
Honor.
matter, get the matter set for show cause. I think that's where we are.
Okay. And I will put on the record, Your Honor, when I did speak with her on the 19th, she was in custody.
In custody in Wayne County?
Correct, Your Honor.
Well, Mary Ann, are you able to verify that since we have a little bit of a lull?
Yes, I can. What is the defendant's name? I'm sorry.
Massey, Massey. First name is Lamika.
Yep, sure. Give me 1 second.
Thank you, ma'am.
Welcome.
In the meantime, there's 24R07625 A and B, State of Michigan versus Villegas. This case was scheduled for show cause hearing pretrial at 8 a.m. It's now 11 a.m. by this court's clock. Defendant having failed to appear. Bench warrant shall issue 1,010%.
Judge, it does not appear that she is in custody. At Wayne County.
Thank you. Mr. Jadala, case will be set for show cause.
Thank you, Judge.
Mr. Reeves, I see Mr. Martin in the breakout room.
Okay.
5S448280 SM, State of Michigan versus Shawan Wilkes. This case was scheduled for show cause arraignment pretrial at 8 a.m. It is now 11 a.m. by the court's clock. Defendant having failed to appear. Bench warrant shall issue 5,010%. I just saw Mr. DiMaggio again. Two 50138 SD. This is State of Michigan versus Deja Bell Lucas. This case was scheduled for arraignment pretrial at 9 a.m. It is now 11:01 by the court's clock. Defendant having failed to appear. Bench warrant shall issue 5,000. Excuse me. Defendant having failed to appear. The matter will be set for show cause. Officer Brooks.
Could I have Sean Wilkes when you get a chance?
I just called the case. Is he here?
No, Mohammed wants it.
Oh, I'm scheduling it for Bring it down for bench warrant. If you want something different, I'll recall the case. Mr. Martin, are you ready with Mr. Reeves or did you need a moment?
I'm ready with Mr. Reeves, and that's Mr. Muhammad's case. And then there is another case that's not on the docket today that Ms. Mandernack and I would like to speak with you about.
Speak to me on the record, off the record.
On the record, making an emergency bond motion for a different client who's set for PCC next week, but isn't held in custody.
Did you tell Mary Ann so she can pull the file so we can have an intelligent conversation about what it is?
I guess I'm telling Mary Ann right now. Thank you.
You're asking Mary Ann to go pull the file for which client, please, sir?
His last name is Ferraru. That's spelled Feraru.
Give me 1 second, Judge.
If I'm thinking about the right person, Mr. Martin, he's on the docket tomorrow for Romulus. No?
Not to my knowledge, Your Honor. I thought he was at a PCC next week.
Then don't listen to me, Mr. Martin.
Thank you.
Judge, don't say that. You're so knowledgeable.
No, I'm not. It's a name that's not particularly common, and I was prepping for tomorrow, and I know I saw that name. But in the meantime, Mr. Reeves, we need Mr. Muhammad. Let's see what are we doing, Mr. Martin?
Today's set for Mr. Reeves's exam. People are not ready to proceed. They filed an adjournment. I'll be asking for dismissal and
Yeah. I received a motion yesterday to adjourn. Mr. Martin, your case isn't scheduled for another 25 minutes. Let's have you sit tight we'll get Mr. Muhammad out here in just a moment. It looks like he has two other attorneys in there.
All right, thank you. I guess Mr. Reeves we won't be calling your case until 11:30.
It'll be a little bit before that, but I'm not, he has a 1045 case in there.
Okay.
And then for the case that was not on the docket, 250201 FY, State of Michigan versus Valentine Ferraru.
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
And good morning, Judge Martin, and to your staff, Neighbor Defender Service, Carrie Martin, P84592. I appear on behalf of Mr. Valentine Ferraru, my client. He is not present today. He's in Wayne County Jail. I would waive his presence for purposes of this proceeding.
Any objection to his appearance being waived, Ms. Mandernack?
No, Your Honor.
What's the issue, Mr. Martin?
Your Honor, I'm asking for a modification of Mr. Ferraru's bond. He has a cash bond in the amount of $2,000, I believe, with a GPS tether condition attached. I've spoken with Mr. Ferraru and also his mother and his sister. They are not in a position to post that bond, and I think due to he should not be held in custody solely on account of his indigency. If he is released on that tether, he is welcome back in the home where he was living before, which is where his mother and his siblings live. That's an address in the city of Romulus. And in this case, I believe that a tether with a no contact order and a restriction zone for the address of this allegation would accomplish everything needed here. And also speaking with Mr. Ferraru's family and with him, he has been participating in some mental health treatment outpatient at Higuera. I believe that's located in Westland, and he would be continuing that treatment. I think he's actually supposed to have an appointment today, which he's missing, but he would, if released, just go back to Higuera and continue his treatment there, which includes medication. It sounds like he's got a lot of family support, a family of Romanian heritage. They're all very close. So I believe that public safety will not be threatened by him being released on tether. Thank you.
I'm sorry, before Ms. Mandernack responds, Mr. Martin, is it your position that they're unable to post any cash amount?
Any cash amount is what they all told me. They just don't have the money. They're behind on bills and everything.
Ms. Mandernack?
Judge, I completely understand where Mr. Martin is coming from. My only concern is that I just attempted to reach complaining witness. I was unable to get in contact with her. I did leave her a voicemail. She did indicate that she is extremely fearful of defendant. It looks like defendant has a previous DV conviction, but it was with a different complaining witness. I would propose the alternative that we maybe set, I don't know if we could set the exam for next week if the court has any spots left. That way I can send an officer to her house to try to contact her. I would just like to confirm with her before stipulating to a bond amendment. I would just feel better if I could confirm with her the defendant hasn't tried to contact her from jail or anything like that.
Was there anything else, Mr. Martin?
I would just say that I did speak with Mr. Ferraru about the no contact provision, and he expressed to me very sincerely and emotionally that he completely understands that he can have no contact with this person. He doesn't have any reason to contact her. They don't have a child in common or anything, though my client does have 2 children that he would like to be reunited with. He's a young man who's very emotional about the situation he's in and his custody, and I think would benefit a lot from returning to his family environment. Thank you.
Mr. Martin, the court's concern is that when you look at a file with a date of birth in 1998 and you look at a criminal history such as what appears in the file, the court does not take the position that Mr. Ferraro is being held in custody because of his indigency. It is a concern for public safety. When you have the allegations of home invasion first, domestic violence, and the criminal history suggests that there's something else. The court is not inclined to have it just be a release onto GPS tether. The court would feel better if there was some financial skin in the game, especially considering that the victim has expressed some ongoing fearfulness. Mr. Ferraro, in completing his application for court appointment, does not indicate how he supports himself, which will give the court some better insight as to what the degree of skin in the game would be. The bond recommendation had been for $15,000, personal bond with GPS tether.
And
wait a minute, let's back that up. And then there's the more recent, that was a bond request from. Oh, wait a minute. I'm sorry. The bond request from February 25th had been for $10,000, 10%. And there's I'm sorry, Mr. Martin, you were starting to say something?
I was only going to say that in terms of his finances, I don't know about employment of anyone else in his household, but Mr. Ferraro is mostly unemployed on account of, he deals with mental health issues, including ADHD, depression, schizoaffective disorder, so which he's been actively in outpatient treatment for, but on account of that, he is unemployed and indigent.
And Judge, it looks like he has a substance abuse issue as well. It looks like part of this incident allegedly stems from defendant coming to complaining witness's house, trying to kick down the doors and windows, demanding money and pills.
So Ms. Mandernack, reading between the lines, you're maintaining your objection to the bond being amended?
That's correct, Judge.
Mr. Martin, respectfully, the court's going to deny your request to amend the bond in any way. The $15,000 personal is for another case in another jurisdiction that happened close in time to this one. The court does have concerns about public safety. There's a case in Wayne and there's a case arising out of Romulus with the same person within the last 30 days. So this court will return the file to the docket we'll be back here on next Wednesday. So if something happens between now and next Wednesday, you're on PCC docket with me at 8:30 a.m. If Ms. Mandernack is able to get a hold of the victim and there's been some change, we can address bond again next Wednesday morning.
Your Honor, thank you. And before we go off this record, I'm wondering if we could go ahead with Ms. Mandernack's idea of actually setting the exam for next week.
If Ms. Mandernack's available, I believe we have time and space.
Yes, Judge.
Is this one? This one's already scheduled, right, Judge?
It's next Wednesday morning for PCC at 8:30. We're gonna move it to an exam on the afternoon.
Sure, at noon.
12 PM, Mr. Martin.
That's great, Judge.
We'll get the information over to the jail to get Mr. Ferraru here, and I'm thinking about the wrong Ferraru. So you were
Right,
correct,
okay.
sir.
Thank you. And Ms.
Thank
Mandernack,
you.
do you have any digital discovery to send me?
I believe I have paper and digital, and now that I know who's on the case, I can send it over to you.
Thank you very much.
Thank you, Mr. Martin.
Sorry, Mr.
Judge.
Mohammed is still tied up with Mr. Fish. Mr. Martin, if you must sit tight for one more little bit of time. We'll recall 5S448287 This was State of Michigan versus Sean Wilkes. The court called the case at 11 a.m. Mr. Wilkes, state your name for me, sir.
Shawan Wilkes.
Mr. Nunley.
And I apologize, Your Honor. He was in the waiting room. He was in the MIDC waiting room. It's just, you know,
I'm sorry, Mr. Nunley. I can't hear you, sir.
Sorry, I will represent that Mr. Wilkes was in the waiting room at 11. He's been waiting for a while. I've just, you know, been chipping away at it. But anyway, Roy Stanley, on behalf of the defendant, for purposes of the arraignment, we'd waive a formal reading, ask the court to enter a plea of not guilty. For the purposes of the pretrial, we are just looking for an adjourned date at this time to get some documentation from both the prosecutor and from the client's employer.
Mr. Wilkes, the court will set your bond in the interim at 1,000 personal. You don't need to post any money, but what you must do is continue to appear as directed by the court until this case is resolved in its entirety. I'll make an indication, Mr. Nunley, that discovery has been requested. How long of an adjournment were you looking for on the pretrial? 1, 2, or 3 weeks?
Could we do 3 weeks?
Yes, sir. 3 weeks will put us on March the 26th at
9:15.
Sounds good.
And that will be in number 2 with Judge Oakley. Mr. Wilkes, notice of that date and time will be mailed to you by court staff. If there's nothing else, you're free to go, sir. You have a great afternoon.
All right, you too.
Thank you. Good afternoon, sir. How are you? I need a favor. Would you ask Mr. Mohammed if he has any objection to the waiver of Mr. Reeves? Oh, thank you. Oh, no, no, no. That's not the right thing. That was not the right question. That was not the right question. That was not the right question. Thank you. Nope, that's not the right question. Thank you. Mr. Martin, I'm gonna make your case go sideways. That was not the right question. Two 3LH00011 AST. This is State of Michigan versus Jasmine Calhoun. This case was scheduled for arraignment pretrial at 9 o'clock. It's now 11:16 by this court's clock. Defendant having failed to appear. Matter will be set for show cause. Mr. Nunley, were you ready with something other than your motion hearings?
No.
Okay.
There's nobody else in the waiting room either. It's just the 3 motions.
Two 40319 FY State of Michigan versus Megan Guerrero. This case was scheduled for PCC at 9:15. It's now 11:17 by this court's clock. Defendants failed to appear. Court has checked the breakout rooms. There is no one by that name. I called you and I got it wrong. It's not, it's Mr. Reeves and your motion to adjourn. Are you ready to proceed on that?
Yes.
Okay. Do you want your, do you need a file or are you ready?
I remember this.
Mr. Martin, are you still with me? Mr. Martin?
I would never do that.
Hello, Judge.
Are you in another court? Do you need to finish up what you're doing?
No, I'm sorry. I'm just
Okay.
at my office.
No, you're fine. I just didn't want to take you away. This is 240892 FY. This is State of Michigan versus Charles Reeves. May I have your appearances?
Good morning, Your Honor. Mohammed Mohammed from the Hampton Legal.
And good morning, Judge Martin, and to your staff, Neighbor Defender Service, Carrie Martin, P84592. Appear on behalf of my client, Mr. Charles Reeves, who appears by Zoom. Mr. Reeves, please state your full name.
Charles Marcus Reeves.
Thank you. This case is scheduled for preliminary examination at 11:30 this morning, yesterday afternoon, and I didn't note the time. The court did not note the time. The court did receive from the prosecution a motion to adjourn the exam with the indication that a key witness, Officer in Charge Jolly, would be out of state and unavailable to testify. The people were requesting a 1-week adjournment. The court does have space available next week. Mr. Martin, what was your position regarding this request?
Your Honor, my position is simply that today is the date and time set for a preliminary examination. The people are not ready to proceed today. They've given a very last minute request for an adjournment submitted to the court with no detailed explanation or corroboration of this officer's unavailability. So on that basis, I would move for the charge to be dismissed without prejudice. Thank you.
May I respond?
Absolutely.
Thank you. In regards to informing defense counsel, I did reach out to defense counsel last week on Friday to see if they would stipulate to an adjournment, and then I don't recall the exact time that I received a response, but I received a response later after that and indicated that he would not stipulate, and so I did follow it up with a motion yesterday. I was off most of last week, which is why I was delayed, but that's just what happened, unfortunately. And in regards to the officer's unavailability, I was informed by the OIC, Detective Jolly, that Officer Durazo, I believe his name is out of town and unavailable. The reason the OIC is not present, I received a phone call this morning when I was here in court from the court actually that the OIC, Detective Jolly, is sick and that's why he's not present here today. And so I'm respectfully just requesting a 1-week adjournment.
Mr. Martin.
Your Honor, I maintain my motion, but respect the court's ruling.
Thank you. It's a two-part thing, Mr. Martin. The court will grant Mr. Mohammed's request to adjourn, motion to adjourn the exam. It would not be because the officer is not available. The court set the exam back on January 22nd, 2025, which gave plenty of time to give notice to the officer and have him present. The court's greater issue is that the OIC is not available. We all get sick. We all have emergent issues, and the court will grant the motion. If you are available next Wednesday afternoon, the 12th, Mr. Martin, we have availability, I think at 12:30.
You have.
I will take the 12:30 slot. Thank you.
Mary Ann, I'm sorry. Did I get the time wrong?
That's fine. 12:30 is good.
It was not fine.
You have one at 12. You have one at 12, so you can put another one at 12 or 12:30.
Let's say 12:30 in case we're in the weeds again. 12:30. Next Wednesday at 12:30, Mr. Reeves here in courtroom number 1.
In person?
In person, yes, sir.
Okay.
Thank you, Judge. Thank you, everyone.
Thank you, Mr. Martin.
Mr. Reeves, I'll talk to you before Wednesday.
Okay.
Take care.
Oh, wait, are we ready on Mr. Nunley's motions?
I am ready, Your Honor.
Mr. Mohammed got away from me. Now I see him out in the hallway. Let me see if I can grab his attention.
Okay.
Send Mohammed in with the motions for Nunley. Thank you. Bye. These are still failures to appear.
Okay.
No, that's me. I didn't even see you when you grabbed them. Yeah, the last time thank you. Mr. Nunley's cases, are you ready? Do you want to grab files? Is there something else you need to do?
I'm gonna be requesting an adjournment.
Uh, Let's, Mr. Nunley, do you want to pull your clients out while we do this? Do you want them present in the court? Well, you know what I mean, present. Do you want them in this main session while we call these cases?
Well, I mean, we can talk about the adjournment, I think. I've already spoken to them and I was aware that
Okay.
Mr. McConnell was going to be requesting adjournment, so I told them that, you know, if we're moving forward with the motions, we'd pull them out so that, you know, they'd all be here, but I don't think they need to be here for this part.
Well, then let me start with Mr. Chapman. This is 241124 SD. This is state of Michigan versus Anthony Chapman. May I have your names to your appearances, please?
Good morning, Your Honor. Mohammed on behalf of the people.
And Royce Nunley appearing on behalf of Mr. Chapman.
And Mr. Nunley and Mr. Mohammed, did you discuss this need for an adjournment before the court called the case?
Mr. Mohammed
It's
did
very
tell me
brief.
that he was going to be requesting an adjournment. Yeah, so we did discuss it.
Okay.
Yeah, there was a very brief discussion. I informed defense counsel that I wasn't present last week, and I actually am not sure if the motions were sent to the APA that was covering last week on Wednesday, but I received them on Wednesday. I was not working Wednesday or Thursday, and so respectfully, I'm just requesting a 1-week adjournment to be able to go through. There was like 6 of them filed, to go through all the motions and review them to have a proper response.
And I would oppose the adjournment. I mean, the nature of the motions, right? Speedy trial motions. I think Mr. Chapman, who we're talking about now, there was a delay of more than 19 months. And I think that the other 2 that I had filed was 2.5 years and more than 2 years with that one. So, you know, as they say, justice delayed is justice denied. These poor people have been, you know, waiting with bated breath to see what their future was going to look like for the last couple of years. So, you know, we're here, we're ready, we filed our motion, we're ready to move forward. And that's really all I can say about it.
And Judge, I would just say, you know, I think I don't want to speculate, but I'm pretty sure that the rules of evidence require at least 7 days notice. And I haven't been technically properly served because I wasn't working, I don't think. And I don't know if that's appropriate to say, but if defense counsel wasn't present last week, then he would have known that I wasn't here and I had an automatic.
I'm sorry. The case was scheduled for last week, but it was adjourned well before that. Mr. Nunley, have you appeared in this case since this court set the date back on January 29th?
We appeared, and then I indicated to the court that we were going to be filing motions on it. And I think it was originally in front of Judge Patton, and then the court reached out to my office and said that it was going to be moved to Your Honor's docket, and then moved it because I think it was originally scheduled in February 26th was when it was originally scheduled, So they moved it to your docket for today. So
the answer to my question is no, you have not appeared since January 29.
That's correct.
And that these motions, the three of them, which I'm guessing the arguments would be similar, were all sent to Mr. Mohammed's email?
They were sent to Mr. Mohammed's email on Wednesday, the same day that they were served to your honors chambers. He was copied on that email.
And Mr. Mohammed, is it your assertion to this court that in your absence, your emails are not reviewed?
Judge, it's my assertion that on the day that defense counsel sent me that email, he would have received an automatic response on that same day telling him that I'm out of the office and that I'm not present. And also, I was not present last week.
The case didn't go last week, and Mr. Nunley is shaking his head that he didn't get an automatic response. Is that what you're indicating, Mr. Nunley?
I did not know.
And just, I can go pull up my emails and provide it to the court.
I can pull it up right now. I'm right in here in front of it. Let's see, sent. Mohammed. Yeah, it was sent on March 4th. I never received any sort of automated response.
Judge, is it okay if I go pull my computer and review the emails?
Absolutely.
Because I was not the person who sent the email, I wouldn't be able to see what he exactly. But what I can show is a test email I did on February 24th, which states, "Hello, I hope this email finds you well. This is an automatic reply. I am out of the office and away from my email and phone until February 28th. So that would have been the email that defense counsel would have received because
Your Honor,
he indicated that he sent that email on February 26th, and that this automatic response was activated up until the date of the 28th.
Your
I can
Honor,
provide that.
we could put
Mr. Nunley.
Yeah, we could put this to bed. I mean, if I can just share my screen real quick, I'll show you the email thread. I mean, it's got the entire thread there. You'll see what I got and what I didn't.
Mr. Nunley, I don't know that that's necessary. We appeared here on January the 29th, and this court had and has received 3 motions, all of the same similar argument. And the court did receive the motions on the 26th. I had Mary Ann confirm that Mr. Mohammed was included in that email string, and respectfully, Mr. Mohammed, even if your automatic reply is on, as a courtesy, I would expect another attorney, if they knew that you were out of the office for an extended period of time, to grant your motions or your request for this court to adjourn these motions one more week. But your indication to the court on the record is that you were back on the office on Friday. And if you then see motions from Mr. Nunley, the court expect to see your request to Mr. Nunley then or Monday or Tuesday requesting that these matters be adjourned over for 1 week so that.
Your Honor, I did respond to the court and defense counsel. The court was in this email where I asked for an adjournment. It was in the email, Judge.
Yesterday at
With the
4:52 PM is when he
I'm sorry,
sent
Mr. Nunley, I couldn't hear you.
I'm sorry, he sent his email requesting the adjournment yesterday at 4:52 PM.
Yeah, that's Mr. Mohammed, that's not a timely request to adjourn a motion. This court closes its doors to the public at 3:30. And although I was here after 4 o'clock, my secretary is not and would have not seen that yesterday. And this morning when I came in, it was not raised with me. That being the case, the court's going to deny your request to adjourn the motions. So that being said,
I'll respectfully request 15 to 20 minutes to review the motions and I can be response to all 3 cases today.
absolutely. Mr. Nunley, I'm going to pass this matter for, let's say, 15 minutes. We'll be back on the record at 11, let's say 11:50.
Okay.
Thank you.
Thank you.
Did you finish with Mr. Fish?
No.
Okay. Hey. I don't want to get like that. I'm going in my office. I haven't asked him yet. 240319 FY State of Michigan versus Megan Guerrero. This case was scheduled at (9:15 a.m. for probable cause. It is now 11:38 by this court's clock. Defendant having failed to appear in this matter, Benchmark shall issue 5,010%. For S 4451448 SI and 241141 SM. These are both State of Michigan versus Darren Palmer. These cases were scheduled for arraignment, pretrial, and pre-hearing at 9:15 a.m. It's now 11:39 by this court's clock. Defendant having failed to appear. The case that ends in 448, which is a civil infraction, will be deemed in default. The 1141 misdemeanor case will be set for show cause.
Vote.
Yeah, they're on the floor, oh my goodness. Some of them have been gone for, but it's in a box. Oh, thank you. 25 WM 00143 SM. This is State of Michigan versus Robert Davis. This case was scheduled for arraignment pretrial at 9:30. It's now 11:43 by this court's clock. Defendant having failed to appear, this matter will be set for show cause. These are 240964 SD. This is State of Michigan versus Alana Eldridge. This case was scheduled for arraignment pretrial at 9:30 AM. It's now 11:44 AM by this court's clock. Defendant has failed to appear. Case is in warrant status and will stay that way. Two four zero four six five FY, State of Michigan versus Robin Nobles. This case was scheduled for arraignment pretrial at 10 AM. It's now 11:45 AM by this court's clock. Defendant having failed to appear, court case being in warrant status, it will stay that way. Two five zero one three zero SD. This is State of Michigan versus Austin Kilmer. This case was scheduled for arraignment pretrial at 10 AM. It's now 11:45 by this court's clock. Defendant having failed to appear, matter will be set for show cause.
Morning.
Good morning. How are you?
Good. I'm Megan Goki. I represent Miss Tawny Peoples. Hello, how are you?
I'm wonderful. How are you? You may take a seat. Ms. Golke, are we holding, waiving, or pleading?
Judge, we would hold if there are witnesses here. However,
Well, let's leave it at that for one moment. Mr. Mohammed should be back in the courtroom within the next 2 to 3 minutes.
thank you.
We have a few other matters that we are still outstanding.
I don't want to shock you on the record. We don't have digital.
That never happens. What are you talking about?
Yeah, I know.
250131 SD. This is State of Michigan versus Anthony Coble. This case was scheduled for arraignment pretrial at 10:15 AM. It's now 11:47 AM by this court's clock. Defendant having failed to appear, this matter will be set for show cause.
That from Mackenzie?
Yep. Okay. Thank you. See, I was trying to get ready for you.
So Judge, I just want to give you a little explanation on these, because it's a little confusing, but essentially, a bond was posted on all of these, so the defense attorney will explain it better, but long story short, they already paid 5,375. So I'm reducing it to whatever they paid, and then apply that money that they paid to cover the payment.
To cover the agreed upon.
Yeah.
Okay.
So I'm reducing it to what they paid and just applying that payment. 'Cause
Okay.
it's posted as bond.
Okay.
So
Thank
it's like 6,000 and they paid 5,000. So I reduced it to 5,000 and then we'll just apply their bond to cover their payment. Which the
Okay.
court has the money already.
Okay. Mr. Fish,
Good morning, Judge. How are you this morning?
I am wonderful. This is 23L023138A. This is State of Michigan versus GFL Environmental. Mr. Mohammed has handed the court the file that indicates that you have authority from your client to plead responsible to this overweight and apply the previously posted bond of $5,375. Was that your understanding and agreement?
That is, Judge.
And so it shall be. Then there is 23L02737880I. This again is GFL Environmental. The court has received from the prosecutor another indication that the court is to accept the plea of responsible on behalf of your client and apply the posted bond of $2,535 in full satisfaction of this overweight citation.
Just to check, Judge, a ticket ending in 378?
Yes, sir.
Yes, that's correct, Judge.
Thank you. 23L027357A. The indication from the prosecutors that you have authority from your client to plead responsible to the overweight and apply the previously posted bond of $4,278 to have that paid in full, and the hydraulic leak reduced to $150. Again, application of the bond will pay that in full. The ticket that ends in 357A.
Yes, thank you, Judge.
And then 23L022884AOI. Again, State of Michigan versus GFL Environmental, the indication from the prosecutors that you have authority from your client to plead responsible to the overweight with a fine of $5,051 responsible to the oil leak, $150, and responsible to the hydraulic leak of $150. Apply the previously posted bond, and that will satisfy the police that are responsible in those three matters on the citation that ends in 884.
That's correct. Thank you, Judge.
And then in 24L022865 A and B, the indication from the prosecutor is that the defective equipment, the B citation would be dismissed. And that the A citation overweight, $4,296 has been paid, posted, and will be applied for the overweight in the A for the file, the ticket that ends in 865 in full satisfaction of the citation.
That's correct, Judge.
And then last but not least, there is 24L027400 A and B. The indication from the prosecutor is that you have full authority from your client to enter a plea of responsible to the overweight with a fine of $3,697. And for the hydraulic tank leak, $150. The court will apply the previously posted bond, and that will satisfy this citation as well. Is that your understanding, Mr. Fish?
That is, Judge.
The court will update our files to indicate that the previously posted bonds will satisfy all of these citations. Is there anything else this morning, Mr. Fish?
That's plenty, Judge, and I appreciate your time and your patience.
Have a wonderful week, sir. Thank you.
Thank you. You too.
Mr. Nunley, we have reached our time. The court is pulling Mr. Mohammed in virtually if he's going to appear physically in this courtroom. Court is ready to proceed on these motions. He's here. He's on the phone.
Okay.
Mr. Mohammed, the court is ready to proceed on these motions, and there is an exam case that is in this courtroom.
All right. Yes, Judge, I'm ready. I'm not going to be responding to the motion, Your Honor, but I'd like to cite to Michigan Court Rule 2.119 that states that a response to a motion must be filed within 14 days after a motion is served, unless the court orders otherwise. The rule in this case is designed to ensure that both parties have a fair amount of time to prepare their arguments and present their case to the court. And respectfully, Your Honor, I was not working last week on Wednesday nor Thursday. The court is aware of that because there was another prosecutor covering the hearing, and defense would have been aware of that because he would have received my automatic response. So respectfully, Your Honor, I do think it's in the interest of all parties in this case that the court respectfully give us a 1-week adjournment so that I can have a proper response to these cases. And to read, I haven't read them.
Mr. Mohammed, before Mr. Nunley responds, I will say for the second time that these cases did not go last week. When the parties appeared in this court on January the 29th, the court ordered that the cases be on Judge Patton's docket on February 26th. That same day, the cases were reset to today. So that there was no last week. And the court rule that you're reading is not the accurate one. Mr. Nunley properly filed the motion 7 days before they were noticed to be heard. That being the case, Mr. Nunley, what was it that you wanted to say, sir?
I was just going to say that he's citing the wrong court rule. I don't know if he's citing the rule for summary disposition motions, but I was just going to point out what the court already did, that there's not 14 days required for a response.
Okay, then I may be, that's what I could pull up in short amount of time, Your Honor. Respectfully, I would request the court to disregard that citation then. But Judge, the 7 days would be 7 business days, and the prosecutor that was working last Wednesday, which the court would have been aware of because the prosecutor was present, did not receive it. I did not receive it. Even though he was sent to my email, I did not have it. I wasn't working. So I don't think the 7 business days would apply. I think it would be technically 5, but also, Your Honor, I think the court could take notice that I cover 3 other courtrooms. And so I'm returning on Friday, but I'm returning for 4 different courtrooms, and I have multiple emails. And so I would request respectfully to have 7 business days to review those emails that I received while I was gone. And if I had received it last week on Friday, it would not be 7 business days. We would only be on day number 4 now. And I did respectfully request defense last week not last week, but yesterday, to allow me to get an adjournment in this case. And so worst case thing that happens is the court dismisses the case, and then we will just reissue the case and start all over it. So if the court really intends on us restarting all these matters, we will be doing that. But I think in the interest of all parties, we can just adjourn this for 1 week respectfully.
Can I jump in real quick, Judge?
Mr. Mohammed, is there anything else, sir?
There's nothing more that I can add, Your Honor.
Mr. Nunley?
So the court rule doesn't require 7 business days. It just requires 7 days, right? And further, there's no exception in the court rule if somebody's out of the office. I'm out of the office once in a while. I wish I was out a little bit more often.
But it requires notice, serving notice. And if somebody's not working, you're not providing notice. If as the court, it was scheduled for last week, but it didn't go. Why it didn't go, I'm not really sure.
For the 3rd time, when this court scheduled it on January the 29th, I noticed it for Judge Patton's docket for February the 26th. On that same day, January 29, 2025, Judge Patton's secretary reset the cases for today. They never went on the 26th of February as previously indicated. There is no requirement that these cases be set, the response time or the filing time, the notice time be 7 business days. It would be 7 days unless day 7 fell on a weekend or a holiday. And if that is in fact what happened, they would be adjourned to the next business day. And when you talk about the interest of justice, it is not the court's care or concern if the prosecutor decides to appeal a decision made by this court or refile a case. But when I look at 241124 SD, and we are now 1 year, 10 months, and 20 days from the arrest, that is not timely. When we look at 241127, we are 2 years, 3 months, and 14 days from the arrest. When we look at 241128 SD, we are 2 years, 9 months, and 4 days from the arrest. I think that Mr. Chapman, Mr. Edens, and Ms. Lawrence have a right to have their cases heard in a reasonable amount of time. I went through Mr. Nunley's motions.
Okay.
And
The delay in time, excuse me, the delay in time between the time that the lab reports were sent back to law enforcement and these cases were issued is unacceptable. Whether
Judge,
the court adjourned it for a week or 6 weeks, it would not change the facts of the case that these people are arrested and we are a year or more before charges are issued. We are a year and 10 months to get here, or we are more than 2 years to get here. So unless you think that something magical would happen between today and next week, or the next time the court will be on criminal docket, which will be April 16th, the facts of the case do not get better with age.
Well,
That
Judge,
being said,
respectfully, Judge, speedy trial issues arise after the charges have been issued by the prosecutors, not at the time of the arrest date. So those dates, while they are important, it's not when speedy trial issues arise. They arise at the time of the issuance of the case, when a judge signs the case and the defendant then becomes arraigned and therefore after. But the defendant was not in custody. So speedy trial does not even apply in these cases. I have to go through each case, but just preliminarily speaking, speedy trials arise after the prosecutor's office issues charges, and that's when speedy trial issue arises, not at the time of the arrest date. So
Mr. Nunley?
applicable.
Yeah. Yeah. Can I jump in?
I called your name, sir, yes.
Yeah, I was trying to jump in. Mr. Mohammed cut me off. I would ask him to respect the decorum of the court and to allow me to finish my argument this time. So first and foremost, he can say that he's going to recharge the files all he wants, but a speedy trial violation requires that the court, if the court is going to dismiss the matter with prejudice. So if the court is inclined to grant my motions, then the motions have to be dismissed with prejudice. Second, the prosecutor's assertion that the right to a speedy trial doesn't start to run until the prosecutor issues charges is just false. It's blatantly false. I can read you all of the cases that I've cited in my brief that say that they run from formal indictment or arrest. I've defined clearly how the court defines an arrest in my brief also. I can go through each case and I can tell you how each of these three individuals were indeed arrested. So Mr. Mohammed's blanket assertion that it doesn't run from arrest, that it just runs from whenever the prosecutor decides to file charges. I mean, common sense would cut against that, as well as the case law, right? So a person can be arrested in 1974, and then the prosecution can get around to filing charges in 2025, and that's okay. That's obviously not the answer, right? And the cases that I cite in my brief all clearly state that the time to judge a speedy trial runs from either formal indictment or arrest. All three of these individuals have been arrested. That's when the clock starts ticking. So if the court has any further questions, I'm happy to answer them. I would just state that the prosecution's arguments that he's made today are just wrong. He cited the wrong case or the wrong court rule for his time to respond to a motion. He just blanketly asserted that he gets 7 business days to respond to a motion, which is just false. I would love to hear the authority upon which he's relying instead of just saying things. And he just says, oh, well, the time to judge a speedy trial runs from arrest. Of course, without telling the court which authority he's relying on. So these blanket assertions, just saying things without any court rule, case law, or anything to back it up, when most of us, when it's pretty generally accepted that what the court rule says about your filing motions and how long you have to respond, I think that those assertions speak for themselves, and that's all I have.
Anything else, Mr. Nunley?
Judge, I would like to respond. I don't just blurt things out. I had very limited time to have a response, Judge. You gave me 15 minutes, but as soon as I came out, I had to handle 11 tickets. So my time limit is very short. And respectfully, that's why I asked for a 1-week adjournment. I'm not asking to adjourn this months out. It's just 1 week. This is the first hearing. And again, I'm restating my position that I believe speedy trials arise at the time of formal charges, not at the time of the arrest. I believe there is case law that supports that. and I would like an opportunity to present that. I understand the court will not issue me a 1-week adjournment, so then I would respectfully request that if the court's gonna dismiss this case, that they not do it with prejudice, so that then we do reissue, if we reissue, we can make our proper arguments. Because I don't believe I've had a fair opportunity to do that, Your Honor, respectfully.
And I would just, again, reiterate that I don't believe that the court has discretion. If the court is going to dismiss, it has to be a dismissal with prejudice.
And respectfully, I'd reiterate to the court that the court can make that decision. Defense counsel doesn't make decisions for the court.
We can iterate and reiterate until the cows come home. The other exam, the 11:30 exam, is here in the courtroom. Mr. Mohammed, the court sympathizes with you. I was also out of the office on Monday, came in on Tuesday to a stack of motions from Mr. Nunley that the court then had to stop what it was doing to make sure that the cases were reviewed, that I checked the deadlines, that Mr. Nunley asserted in his motions to be true and accurate, to read the authority cited, and to do other research to make sure that the court would proceed properly. For the prosecution to send an email to the courthouse at 4:52, the day before the motions are heard, when you acknowledged on the record that you were back in the office on Friday, is not acceptable. The court takes issue that Mr. Nunley was included in the email chain where you were asking for the request, but he didn't respond. At 4:52, I wouldn't expect a response from him, but the court has read the motions. In 241125, State of Michigan versus Anthony Chapman, the defense motion to dismiss with prejudice is granted. In
Well, Judge,
241127 SD, State of Michigan versus Ricky Ettins, same outcome. Case is dismissed with prejudice. 241128 SD, State of Michigan versus Maryland Lawrence, case is dismissed with prejudice. The defense motions are granted. Mr. Mohammed, you have an absolute right to disagree with this court's ruling. Your office's options are to file a motion to appeal or take some other action. Unless there's anything else in this case, this court is ready to move on to its 11:30 docket.
Well, Judge, the court never responded to what I stated in regards to speedy trials apply at when formal charges are brought, not at the time of the arrest. What's the court's position on that?
My court's position is that Mr. Nunley's motion addresses that. The authority cited his motions address that.
Understood. Thank you.
Thank you.
Thank you, Your Honor.
My apologies, Ms. Goki and Ms. Peoples. The court needs to take a 15-minute recess. I will be back out here at 12:30. To the other people who are waiting for the exams, my apologies. I'll be right back.
Ricky, Marilyn, Anthony, I'm going to move you back into my waiting room briefly, just so I can kind of debrief you guys, and then you'll be free to go, okay?
Okay, thank you.
This is one of the nicest courthouses. Oh, you never been in New York? No, this is beautiful.
Yeah, you've been in about 2.5 years. Really? Okay. They actually started playing everything before COVID.
Okay.
And then they started building right before COVID. But if we'd known what COVID was gonna do to the court systems, with everybody's going to Zoom, they would never build this.
Well, okay, yeah.
Just, old one, we put between 600 and 1,000 people through there a day.
Yeah, it was, half the size of this.
It was a quarter.
A quarter of the size.
It was 18,000 square feet, and this one's like 58,000. So when we moved into this one, everything was so Zoom. They were lucky to put 100 people through here again.
Like
state building had plenty of room.
Right. Hadn't realized it had been out here. What a nice environment to work in.
Yeah, it's a nice building. Very nice. I mean, the first day we moved in, the roof leaked, stuff like that, but that's
What's gonna do, right?
Yeah, it's gonna happen.
Yeah, the lakes behind there.
Yeah, it's
Really nice.
And this is one of the smaller courtrooms.
Really?
Judge Green, well, it used to be Judge Green before she retired, but her courtroom's like it almost looked like a church. It's got views all the way around the sides.
Oh,
it's for when you have the big cases,
right.
Yeah.
Nice. I almost feel bad. I don't want to beat up on Mr. Muhammad after that.
He's used to getting beat up every day.
I felt embarrassed. I was like, it felt like my dad being disappointed in you because you didn't do your work.
Right.
And I'm like, I don't have a little bit of it.
Right. You know, the problem is they're so short staffed. Right. They don't have, they take a day off. They're screwed, right, you know, so it's staffed, so.
I mean, I've been there.
Yeah, oh, yeah.
I still did my motions.
Yeah. That's pretty.
Yeah, I haven't been on the prosecution side. But I was doing misdemeanor, I was in New York doing misdemeanors. And my first day, it's like 350 cases.
Wow.
I got found on the Friday. That you were in?
So we just didn't sleep. Okay.
Yeah, those were rough several years.
Were you in Manhattan?
No, I actually worked at Neighborhood Defenders of Manhattan before law school.
Okay.
But I practiced in Rochester.
Oh.
For 5 years. Yeah. No, it wasn't definitely at the end of and you gotta think.
Oh, yeah. I got accepted to NYU, but it's 40 meters, 7th level, it was like, yeah, it's been, like, I can't go.
Yeah, yeah. I don't know how people will do it. They did not let me in Brooklyn Law School, and I was like, I can't do it. Although I could go to Ohio State, I think it's more expensive, but the law school.
Oh,
It was like in-state tuition your second 2 years, but it's still like, 50K or something.
yeah.
What else is gonna happen with those anyways?
True.
I think I have about a year left on my public service loan forgiveness. See,
You got an exam up there?
yeah, but I don't think it was.
Yeah. Kind of a strange case. The implication of my understanding about a video.
That doesn't sound like the best evidence.
Right.
Yes, you're saying.
Right.
Well,
And what I don't want to do, bring on. That's, you know.
Able, if I'm here identifying it. Yes, the only persons in the next two people here.
Right, see, that, suggest that they have. Yeah, but, yeah, my. Something fan this tall, and it's no way it's the same. What was it?
Again. We'll see, that's cool, that's interesting.
Every case has got a little twist to it, you know?
What is, that's what's fun about it, right?
Hey, what are we doing? You want to move it?
Yeah.
Why is there no OIC?
He's not with friends.
Okay, is anybody here?
Yeah.
Okay, this is.
Yeah, that's what we're trying to get you to say.
Oh. Well, I thought you said just OIC, I didn't put no off.
No one's here.
That'll be this.
Okay.
What I'm trying to do is say goodbye.
Have your client take this beer? I don't think so.
He's used to it.
Yeah.
Bye.
Feel great. Break. Where? No. Who's that?
Yeah, if you. 30 seconds. Yes. No. Yeah. They started. Cheating. Shipping work. Yeah. Yeah. Yeah, it's all interesting. Oh, yeah, he came. Shock. Wait. Oh.
To be right out. Maybe seated. You're fine. Is this what we're doing? This is you. Oh, thanks.
What time is Paul's schedule for?
People's is 11:30. We're running behind schedule, but it's me, it's not anyone else, so we'll try to catch up here in just a moment. Thank you. 241180 State of Michigan versus Peoples.
Your Honor, Mohammed on behalf.
Yeah, Judge, I can go. P number 88091.
Switch places for me, please.
Representing people, standing fair.
State your name for me, ma'am. Thank you, Ms. Peoples. Today is the day and time scheduled for the preliminary examination in this matter. There is count 1, possession of controlled substance less than 25 grams. There is count 2, possession of controlled substance less than 25 grams. And count 3, the misdemeanor that's traveling with it. Are the people prepared to proceed this afternoon?
Move forward, there was 4 officers, I believe, subpoenaed, no one's appeared. This case scheduled for 11:30. I need to move forward at this time.
Ms. Gilkey?
Judge,
Based on the prosecution's position that they're unable to proceed, that none of the 4 witnesses that were subpoenaed have appeared, the court will grant the defense motion to dismiss. That dismissal is without prejudice. Is there anything else in this case, Mr. Mohammed?
Okay.
Anything else, Ms. Gilkey?
Nothing.
Then, Ms. Peoples, that concludes this matter. You're free to go. You have a great afternoon. Good luck to you. Do you need a minute to talk to the 12 o'clock?
No.
Okay.
Yes.
Wells?
Well.
Thank you. 240377 FY State of Michigan versus Alvin Wells. May I have your appearances?
Good morning, Your Honor. Good afternoon, Your Honor. Mohammed Mahad.
Good afternoon, Your Honor. May it please the court, Douglas Mons, P 40916 on behalf of the defendant, Mr. Alvin Wells, who stands to my right. So, state your name and then place off the record. Alvin Wells.
Thank you, Mr. Wells. Today is the day and time scheduled for the preliminary examination in this matter. There is count one, receiving and concealing of stolen property, 1,000 to 20,000. Are the people prepared to proceed?
Your Honor, people are unable to move forward. None of the subpoenaed witnesses have appeared today. Due to that, I'm unable to move forward. This case is scheduled for 12 o'clock. It's now 12:37. And again, there's no witnesses present, so I'm unable to.
Let's move forward, dismissal without prejudice.
Defense motion to dismiss is granted based on the witness's failure to appear in response to subpoenas. Is there anything else on behalf of the people, Mr. Mohammed? Anything else on behalf of the defendant? Thank you. Mr. Wells, that concludes this matter. You have a wonderful afternoon, sir. Thank you.
We're writing on John Johnston. It's gonna be a waiver. Yes.
Yes, sir. Give me 1 second. Two 0647 FD, State of Michigan versus John Lloyd Johnson.
Good afternoon, Your Honor. Mohammed.
For the afternoon, Christina Johnson, the neighborhood defender, so it was a key 45400.
I'm sorry, Christina Dunn. Thank you.
Not here for Mr. Martin.
Ms. Dunn, the issue is this tall ceiling and that fan blowing. I can hear. Mr. Johnson, your name for the record, please. Thank you, Mr. Johnson. Today is the day and time scheduled for the preliminary examination in this matter. There is count one, operating while intoxicated or impaired. Third offense, operating while intoxicated, misdemeanor that's traveling with it. Mr. Mohammed, are the people prepared to proceed?
Judge, I spoke with defense counsel on this exam with England.
That is correct. I have advised Mr. Johnson of his right to a preliminary examination. He understands those rights and we are giving.
Mr. Johnson, would you raise your right hand for me, please, sir? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may put your hand down. Sir, you've had the opportunity to discuss this case with your attorney, and you understand that you have an absolute right to have a preliminary examination where the people would have to show that both a crime had been committed and that probable cause exists to charge you with that crime. And after having that conversation with Ms. Dunn, you wish to waive your right to have that exam.
Yes.
And you're doing so freely and voluntarily?
Yes.
You haven't been threatened in any way or promised anything to waive the exam. I've passed the file down. Ms. Dunn will sign that you're waiving that exam. You will need to sign as well, so I'll stop talking while you discuss it with her. And so long as you and Ms. Dunn have signed the waiver indicating that you're waiving your right to have the exam, Mr. Mohammed will sign indicating that the prosecution has no objection to the waiver. Once the form comes back to me, the court will find that your waiver of the exam has been freely and voluntarily given. All necessary parties have signed the form. Mr. Johnson, you will be now be bound over as charged. Your next court date will be an arraignment on the information at the Criminal Justice Center in downtown Detroit. That will be on March the 19th, 2025 at 9 a.m. Your previously entered bond with any of its conditions will continue unless there's anything else on behalf of the people, Mr. Mohammed. Anything else on behalf of Mr. Johnson? Then, Mr. Johnson, you are in fact bound over. That concludes the matter for the afternoon. You have a wonderful day. Good luck to you. Thank you. Oh, I spelled it wrong. It's Dunne.
Okay, got it.
She's on the next case.
I'll just do it. Yeah, I'll just.
Ms. Goki?
I was,
On Mr. Kennedy?
I'll just,
I'm sorry, Ms. You're fine to stay there. We had a 12 o'clock case with Ms. White and Mr. Cabell. I don't know what the status of that case is.
okay. Oh, yeah, definitely.
I brought a whole huge.
You mean that? Well, I'm looking. I like your shamrocks.
Thank you. That, you know, I tried.
I don't remember the sparkly one.
From last year?
Mm-mm.
Oh, yeah. And then Easter will be here before we know it.
Can I ask you a question? Nothing to do with that. Yes, I know. I just got a message. And she said, you know, and I just, and she said, I see that the department is gonna have airport DWS dock in June. So that's why I was looking at the calendar. You have Monday. Did something change then? Airport? Is airport on Mondays?
It's like once a quarter or something weird. Don't you remember they said it like a year ago? We just haven't had it and I don't know why.
Okay, so then you have it twice in June, 2 Mondays in June, the first Monday and the last Monday. And I just wanted to talk to you and say, hey, did I miss something here?
You didn't miss it.
Okay.
It wasn't on the calendar already? Did it just get
I
added
had
to
an
the
old
calendar?
calendar. I had an old one.
Uh-huh.
So I just pulled it up and it's on the calendar.
Oh, it was on the calendar. I can't remember why they added it, but I knew it. We just haven't had it in a long time. I just
Okay.
couldn't remember what the rotation was.
Okay.
Oh, what happened to Mandarin? Oh, so like.
But you know what?
This is what we should.
What made you want to start streaming?
Because you're paying for it. We should use it.
So is that gonna be a thing now?
Today, yes, maybe twice a month. Today and next Wednesday. That's it.
Okay. No, I think you didn't vote. Yeah.
So what are we doing tomorrow? I said, what are we doing tomorrow?
Heck. Moving right along today, huh? This is gonna be a whole. Living a whole bunch, so.
Mr. Kennedy, you can have a seat, sir. I'm sorry. I didn't know what we were doing. I don't know. I'm just here so I don't get.
She is.
Just walk by.
Oh, okay, cool.
So what I would like to do is get us signed up for the Memorial Day Parade. I think the court should participate, possibly. I don't know.
A parade in Romulus?
In Belleville,
Court?
possibly. Just like I think we should do the Christmas parade, but they don't call it Christmas, they call it Winterfest. I think our responsibility extends beyond the
The walls of Lower House, I think so. Except I'm waiting to hear about tomorrow. Don't walk away from me like you don't hear me. Oh. What do you do tomorrow?
Nothing.
Okay. We have a docket tomorrow that I need to finish reviewing. Tomorrow's one.
Well, you'll find out soon. I'm sure it's my birthday.
Oh, I felt that. That's why I think we should do something.
58, you believe that?
Good, dude. I love that story.
68. Yeah. Hey, when they were wheeling in, that
What?
when they were wheeling me into the operating room for this last surgery, before they put me out, the nurse is reading off all my evidence to me. Asking me if they're right. I said, yeah. She said, she looks at me and she says, man, you're in pretty good shape for a guy with all those problems. Pushes that in, I'm out like a light.
Last thing you remember. I'm gonna give Ms. Vanderneck a few more minutes because we're down to 3 and it's only 4 to 2 now. I hated to leave my meeting because it's interesting. What are we doing? Oh, yeah, Johnson. We have Cabell, Kennedy, and McKay. And for the fish cases, if you have questions about the note, let me know. Okay, yeah. I just wrote on there, apply the bond and close, because that's basically what they did in each of the files. They didn't. Okay. But there were so many of them, I'm like, I'm not. You're not gonna write mine over. It is on every one. Oh, it is. But I don't, it's clear to me, and it was clear to Fish in the moment, but when you go to Dispo, make sure it's just applying the bond. All, they were the vault status for some reason, and so they got back on this docket and just apply the bond and close it out. What else is going on tomorrow other than Romulus? I don't know of anything else. What else is scheduled?
It's a late night.
So late night on your birthday?
Of course, I don't stop overtime.
I am so. I'd say, wait a second, I've got plans to go out to dinner.
No.
Yeah, going out to dinner?
No,
I'm not gonna pack
Saturday.
up on a Monday,
It's
Tuesday, or
coming.
Thursday. Saturday?
Well, see, I'm worried about, because I wanted to tell you, I'm going on vacation. I won't be here from the 24th until the 28th of March.
Where are you going?
Our cruise that we go every year.
Just the two of you?
Yeah. But I'm missing 3 days overtime.
Oh, shit. I don't know what to do. So I start looking at a new chair. Did I tell you? No, I think it's about time. Well, because when Judge Patton was looking for a chair, I flipped this over to see what it was. It's just a lazy boy. Yes, sir.
Is it possible to get a copy of the dismissal or dismissal or whatever?
Oh, you can get it on the web. Yep, I have. It's not a freestanding order form. It'll just be on the ROA. So when she updates the ROA,
Okay,
unless you want it some different way.
no, that's fine.
Okay,
Thank you very much.
you're welcome, sir. Because you can't turn it up. When I look at it for her, I wanted to see if I can make it higher. Yeah. Little short thing. Well, first of all, I'm as tall as I need to be. Are we ready, Ms. Mandernack?
Oh, yes, it's the victim just ran to the bathroom.
Okay.
No, not yet. I haven't called the case. If you want to have no, you're fine. If you want to have a seat, just,
So those are my bad.
you're fine. You're fine. This is 240849, State of Michigan versus Daniel Kennedy. May I have your appearances?
Good afternoon, Your Honor. Patricia Anderson for the people, the 84088. Good afternoon. The name of the defender service by Christina Dillon. 490, Mr. Kennedy, this meeting.
State your name for me, please.
Daniel Creighton.
Thank you, Mr. Kennedy. You may take a seat, sir. Today is the day and time scheduled for the preliminary examination. So, great bodily harm less than murder. And count 2, there is a domestic violence misdemeanor that travels with this felony. Ms. Mandernack, are the people prepared to proceed?
Yes, Your Honor. I move for an order of sequestration with the defendant.
If there is anyone in the courtroom other than the OIC who is giving testimony or will give testimony at some point in the future, you should absent yourself from the courtroom. If you are viewing these proceedings and you are likely to give testimony at any point in the life of this case, you should stop reviewing the matter. Any other preliminary issues, Ms. Mandernack? Ms. Dunn, any preliminary issues? Thank you. That being said, your first witness, ma'am.
Thank you, Your Honor. The people called Sherry Lannon.
Ms. Lannon, I'm going to have you come up here, please, to this black chair that's closest to me. And before you sit down, we need to do 2 things real quick, okay? I need you to state your first and last name and spell them both for me.
Sherry Lannon, first name Sherry, Cherie, last name Lannon, Lannin.
And then raise your right hand for me. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
It is.
Thank you much. You may have a seat in that chair for me, please. My secretary is recording your testimony. If she has any trouble hearing you, I'll ask you to either raise your voice or move your body closer to the microphone, okay? Thank you. You're fine. Ms. Mandernack.
Thank you, Judge. Good afternoon, Ms. Lannon.
Good afternoon.
I'm gonna take you back to, August 27th, 2023. Where were you that day?
5966 Airborne.
Okay. And what city is that in?
Ramos.
Okay, and that's in the county of Wayne?
Yes.
And what's at that location?
The home of Mr. Daniel Kennedy.
Okay, do you think Mr. Kennedy in the courtroom today?
I do.
Okay, could you please point to him and tell us something that he's wearing?
A yellow button-up and gray.
Your Honor, I'd ask that, the record reflect that complaining witnesses identify the defendant.
Yes, ma'am.
And Ms. Lannis, how do you know Mr. Kennedy?
I was in a relationship with him.
Okay, what kind of relationship?
Boyfriend, girlfriend.
Okay, and just, if you could shout at me.
Sorry.
No, it's okay, or you can bring the microphone closer to your face, but I always tell people to shout so the microphones can pick everything up. Did you have any children in common with Mr. Lannon?
Yes, we had 2 kids, one is Zachary Kennedy.
Okay, and did you live with him at any point?
I did.
When did you live with him?
From 20.
If you were
14, 15, on and off all the way to 2023.
Okay. You said 2014 to 2023?
On and off, yes.
And going back to August 27th, 2023, did something happen that day that brings us to court?
Yes.
What happened? Or I'm sorry, how did the incident start?
Incident started when I even went to work and I had not been doing the dishes. I did not do the dishes. And we both got into an argument.
Okay, and what happened during the argument?
We got into a physical fight.
Okay, how did the physical, when did it get physical?
When I went to walk away, we grabbed a cooking sheet, so we ran it.
Okay, did he say anything when you went to walk away from him?
as we move it.
Okay, and you're allowed to use the full expletive. Judge Martin will not be offended. And what happened after did he say anything while he was smacking you on the head?
That's
Okay.
There's everyone.
What happened next?
Next, I fell in front of the front door, and then, I went to get up and ended up under the kitchen table, proceeded to kick me under there, and then walked away. And I had a tote underneath the TV and I was going to pull my belongings.
Okay, and I'm sorry to interrupt you. Why did you roll under why you said you rolled under the kitchen table? Why did you roll under the table?
To hide.
What were you hiding from?
Yeah.
And you said, what happened when you went to grab a tote bag?
When he went to go get the tote bag out, I proceeded to get up and grab my belongings and throw them out into the yard. And that's when I walked out, then he came out with I can't remember if it was a towel or a sheet for bedding.
Okay. Do you know about how long the towel or sheet was?
Probably like a little over 4 feet.
Okay. And actually, sorry, I'm gonna back up to I'm just gonna back up a little bit. When you were under the table, when did you get out from under the table?
When he proceeded to grab my things out of the tote and walk them out and throw them out in the yard.
Okay, what things were in the tote?
I had clothing, I had pictures, personal belongings, the kids' belongings, toys, America.
Why were you grabbing the tote bag?
I was planning on leaving.
Okay, why were you planning on leaving?
I didn't want to be there.
And you said he was throwing your items out of the tote bag. What happened when he was throwing your items out of the tote bag?
I had proceeded to go grab my stuff out of his hands and that's.
Okay, what do you mean by got into, or what did he do when you went to grab the bag out of his hand?
He yanked it out of my hands.
Okay, and I'm sorry, I just want to be clear. So he had the tote bag and was throwing things out of it. Did you get it in your hands at any point?
It was like a backpack that had strings on it. Not a big backpack, but I had grabbed my hand on the strings and he had the other part of the strings pulling. As he was trying to throw it out, I was trying to pull it in.
Okay. Did he say anything to you when you were trying to get the bag?
Yeah.
Okay. And did you say anything to him when he grabbed the bag?
Giving myself, that's all I have.
Okay. And what happened when you grabbed the bag from him?
I was laid down to the ground.
Okay, and what happened when you were on the ground?
He proceeded to lean over me and that's when I got punched.
Okay. Did he say anything when he was punching you?
I don't remember.
Okay, do you remember how many times he hit you? Okay.
Got my lungs.
Okay. Where did he hit you?
In my left eye. And then I know the kids were coming through the door. And I was leaned up against the couch and told him to get out. And that's when as the kids left.
And I'm sorry, did you say you told him or that?
I told him the kids to get out.
Okay.
And he told me don't you ever tell my kids to leave the house.
Okay. And then what happened next?
Then he took his feet and slammed while I was running sideways and he like jumped on my ankles.
Okay.
And then my daughter saw it.
Okay, and then I want to back up a little bit. You said at one point he grabbed a sheet or a towel.
Yes.
Okay, what happened when he grabbed the sheet?
Grabbed her around the neck. Okay. He proceeded to pull me out of the onto the deck.
Did he say anything when he wrapped the towel or blanket, or I'm sorry, towel or sheet around your neck?
Yeah.
Okay.
That's the only thing I can remember. And I think it was
when he wrapped the sheet or towel around your neck, did it squeeze or apply pressure to your
Yes.
throat? Okay. And did you have any changes in your breathing? What were those changes?
And fingertips, everything started slowing down. I was grabbing at it, trying to untangle it, so it's twisted. And then I just had to see him. Instead of fighting, drag. And he ended up letting go when we got to the end of the porch, or to the middle of the porch.
Okay, so you said that when he had the sheet or towel around your neck, everything slowed down.
Yes.
Can you explain what you mean by everything slowed down?
Everything just seemed like slow motion, everything was kind of not physically numb, mentally numb, so, pretty good.
Okay. Did you have any changes in your vision? Did you lose consciousness at any point?
No, it just, the slowing, the breathing was really angry for 3 minutes.
Okay.
Few seconds.
Okay. And what happened next?
We ended up letting go and walking back into the house, and then, the trailer, I laid there for a little bit to take a few breaths. I got up and went back inside, inside and, sat on the couch, and when I sat on the couch, and when he was there too, and I asked him for a little bit stop, and start acting right.
Okay. Did you have any injuries as a result of this incident?
Black eye, this is front tooth.
And did you call 911 on the night of August 27th, 2023?
I had called, I had gotten a call for adult protective services. I did not call them.
Okay. Do you know who, did police come to your house on August 27th, 2023?
They came August 16th in the afternoon, and then they followed up August 17th in the afternoon.
Okay, so that was about 10 days before this incident?
I'm sorry, no, there was days like it was, I don't know. I know the police said showing up the day before the week's done, so.
Okay, when did you go to the hospital?
I'm not sure.
Okay. Was it before or after the incident?
It was after the incident. He had came home from work, and his arm was really enlarged.
Okay.
So I had called. I went to call the 911, and told me not to, so I hung up. And I went next door and got the neighbor to take him to the hospital
Okay.
for his arm.
So just to be clear, you did not call 911 on the night of August 27th?
I didn't know.
Okay. Why didn't you call 911?
I just didn't know how to handle all that.
I'm sorry?
I didn't know how to handle all that process.
Did you eventually tell the police what happened? Or actually, let me start it this way. Did the police come to your house after the incident on the 27th?
They did.
Okay. Do you remember what day that was?
I want to say when we get his arms.
Okay. Did you speak with the police?
On 2 occasions, yes.
Okay, what happened on the first occasion?
First occasion was the being called for adult protective.
Okay. And you said, and I'm sorry to interrupt, you said that was before the August 27th
Yes.
incident? Okay. Sorry, go ahead.
The second one was, I believe, following day after, and that was to, because they had said they were gonna come back, that I told him now was not the time, so that he back home again.
Okay, why did you tell them now was not the time?
Because he was at home.
Okay, why didn't you want them to come when he was in the home?
I will just.
Okay. And did you eventually make a report to the police?
I did, they followed up the following day, and he had just left for the hospital probably an hour and a half prior to that, and they showed up.
Okay. And, why did you talk to them that?
And they were pretty determined to get it out.
Okay.
And I was sorry.
And you testified earlier that you received a black eye?
Yes.
Okay. Sorry, I asked for just a brief indulgence.
Yes, ma'am.
Judge, I am showing what defense, or I'm showing defense counsel what I would mark as post one.
And Your Honor, I have no objection to the witness testifying about this. But we haven't laid a foundation as to when this photo was taken or anything about it. Issue.
Yes. I'll lay a foundation. I was drawn into law school, always defense counsel before you approach, so. Actually, and then I'm also gonna show you people's proposed to on fire. Yeah. Your Honor, may I approach?
Yes, ma'am.
I'm showing you what's been marked as people's proposed exhibit 1. What am I showing you? Okay. Do you know when this picture was taken?
I am not.
Do you know,
The second time the police officers came,
okay,
and I made the police report.
okay. And do you have any injuries in this photo?
I did.
Okay, or actually, I'm sorry. Do you know who took this photo?
Officer Dorsey.
Okay. Or a police officer took this photo? Okay. And is this and I'm sorry, you said you had a mark on your face?
Yes, top left eye.
Okay. And is this a clear and accurate representation of the mark as it appeared on your face at that time?
Yes.
Your Honor, I would move to admit people's proposed 1 as people's 1.
Any objection? It's received. Thank you.
I'm showing you what's been marked as people's proposed exhibit 2. What am I showing?
The left side of my face.
Okay, and are there any injuries in this photo?
There are.
Okay, what injury is there?
Bruise upper left eye.
Okay, and did you have that bruise before the incident on the 27th?
No.
Okay. And is this, do you know who took this photo?
An officer.
Okay. And is this a clear and accurate representation of your eye as it appeared on that time?
Yes.
Your Honor, move to admit people's proposed 2 as people's 2.
Okay.
It's received as people's 2.
Thank you. Permission to publish?
Yes.
Would defense counsel like to approach?
I see the photo.
Okay. So that's people's proposed 1. And just let me know when you want me to move.
Now. Thank you.
You're welcome. And I will send these to the court. Your Honor, I will.
Thank you. It's done.
Ms. Landon.
Yes.
And I am Christina Dunn and I represent Mr. Kennedy. So I'll try and speak up also. So I want to take you back to August 27th, 2023. You testified today that Mr. Kennedy came home from work that day, correct?
Yes.
What time of day?
I don't remember what it was.
I'm sorry?
I don't know. You have laid out.
late afternoon, was it August, was it still light outside?
Yes.
So sometime before 5 p.m.
Don't believe it was. I'm not sure.
And where, if you know, is that the normal time Mr. Kennedy would come home from work?
No,
What was the normal time?
it was normally later at work at that point.
Do you know why this day was unusual?
He would periodically, once in a while, show up at the house just to come in and show me.
It was his house, correct?
Yes.
He lived there, correct? So when you're saying he showed up to check in, what do you mean?
Just coming back and hang out for a little bit.
And you were living there, correct?
Yes.
Did you have another resident of any kind? So you were actually living at that home? And it's true that his children, your children were living there at that home as well?
Yes.
And that he had custody?
Not sure about full custody at that time. I'm not, that's all I'm saying.
Was it your understanding that the children were properly living in that home, Mr. Kennedy?
Yes.
And
was
they-
living here.
that is where the children went to school, correct?
Yes.
From that neighborhood?
Judge, I'm gonna object based on relevance, I would ask that you just make us be there a little bit.
If I may, the truth is that the statute requires proof that either they live together, they had a prior relationship together, so I just wanted to establish that. I think it's appropriate.
Your objection's overruled.
Thank you, Your Honor.
You testified that this was late in the afternoon and you immediately got into an argument with Mr. Kennedy, correct?
Well, not immediately, we have, and I did not do dishes, I was not doing cut off. And, he came home and started yelling and shouting about, no, I don't do nothing around.
And your testimony is that he immediately hit you over the back of the head during the argument with the sheet?
No, he said he was sick of me and he wanted me out and was tired of anything.
So we had a verbal argument and then your testimony is that it became a physical argument. And then the cookie sheet somehow came into play.
I wanted to walk towards the front door, not out of the front door, but towards the front door to the living room. And he was thinking about how dirty it was. That's the problem.
And he asked you to leave the home before this day.
There's been a few times throughout the years.
How long have you been staying there when you were there?
I believe 4 months.
So you testified that after the cookie sheet, that you were struck with the cookie sheet, that there was continued physical altercation, true?
Yes.
And testified that this happened indoors, correct?
Yes.
You're sure none of it happened outdoors?
When I was dug outside, it was outdoors.
I'm talking about the punching that led to the, that we saw the picture.
No, that was in the room.
And you testified that children were in the home at this time?
They were outside playing, when I had went to the floor and they opened up the front door. And they barely got the front doors back to get out of the home.
And so the striking took place while you were laying on the floor, correct?
Correct, and the kicking was placed in the.
Did you suffer any, you didn't testify about any injuries that occurred because of the kicking, correct?
Well, kicking was more like I turn like this. Into the face.
And then your testimony is that you don't know what was used, but some kind of piece of fabric was used to
It
drag.
was either
No, I'm just, that's my question. Your testimony is that some piece of fabric, you're not sure what it was used to drag.
that, it was either not a fitted sheet, but a throw sheet. That goes on top of the fitted sheet, or it was a long towel.
And how do you know it's one of those items?
Because That's, I had towels on the couch, and then I had like the laundry, I think it was by the front door.
Did you give that item to the police when they came?
I did not,
Did they ask for it?
I believe not, I didn't know.
Did you describe this incident to the police?
I did,
And you also testified there was a struggle over a bag, is that correct?
there were several objects, but that is what, so it's a. You know,
Not, I didn't ask the question, I just asked if that was something you described.
yes,
And the bag is described, as you described, a backpack with like string backpack straps?
yes,
And you indicate that's everything you own in the world is in there?
yeah,
Is that true?
yes, and that told,
And you were living in this home?
yes.
You had no other items of yours around the home?
No, he had taken all the curtain lines, couches out of the house, cabinet shut, the fridge was bolted shut, I had a bolt shut on, bedroom door, padlock. Yeah,
Well, I'm asking about whether you had things in the home. Did you have anything else in the home?
that was all my belongings.
And you struggled over that bag because you wanted to leave, is that right?
No, he was trying to throw it out in the yard and show it,
And was it ever thrown in the yard?
yes,
And did you give that bag to the police or show it to them when they came days later?
no, I put all my stuff in suitcases underneath the trailer to go play on.
So back to my original question. So you had additional items you needed to put in suitcases?
You know, what was in the coat? I had to use my kids' suitcases. For the day that I went to go leave that night, I put my few pairs of underwear, bra, a couple shirts, and most of my kids' stuff in my suitcase.
When did you do that?
The night before the day he went to the hospital, the following day is when I put everything underneath the trailer, taking him to come home.
Well, we'll get to that in a moment. I don't think I've gotten to that point in time yet. I was thinking about this exact day. You had a backpack, string straps, that's everything you owned in the world.
Yeah, they were having like, knickknacks, with my grandma's stuff, pictures in it. Some artwork I had done with the kids, the total was maybe this big.
Oh, so it's pretty large.
Yeah.
And I understand that.
This tall.
And Judge, I would ask for reflecting the complaining witnesses how her arms out about the width of the witness stand, when indicating how wide the bag is, and I believe that was about a foot. A foot tall?
Maybe.
I have no objections to that characterization.
Thank you, Ms. Dunn. Thank you, Ms. Mandernack.
Backpack itself was only like, it was really thin, with, bag, my person's.
So I'm gonna move to when things happened outdoors. And we would testify that Mr. Kennedy dragged you or drug you outdoors. And was that downstairs on the trailer?
No, so the front door, there's a beam right here, you got the kitchen, the dining room, it started at the floorboard of the door. Right, and then it went out to towards the same level. All the way up to the rail, and then the steps are on both sides, I didn't touch the steps.
So when did he start dragging you indoors?
Out the front door.
So you start, I'm sorry, to interrupt.
I'm sorry.
You start indoors, and he drags you through the door, is that right?
Dragging me through the door onto the porch.
And he's this whole time you're being pulled by your neck?
Yeah.
Did you suffer any injuries from that, being dragged?
No.
And then you were dragged down some stairs?
No, we were close to the edge of the rail. And then I ended up letting go.
And then you walked out the door.
And then I laid there for probably minutes.
This is during the day or light time, still in August, correct?
Late afternoon.
And you have neighbors nearby?
I do.
You were laying on the ground outside the trailer for 15 minutes? Yes. Did you happen to see any papers during that visit? So you stayed at this house after this incident, correct?
No, I left, with someone.
On August 27th, you left?
I believe it was on 28th, but that morning.
So that the day that this assault occurred, you slept that night in the trailer, correct?
He was not there. He was in the hospital.
That's not my question. You stayed that night in the trailer, the night of August 27th. And you stayed there with the children?
Yes.
And it's your testimony now that Mr. Kennedy was in the hospital starting that day, the 27th?
I do not know the date when.
But do you know that it was there that night?
He was not. He had, I believe, was working at a friend's house on the floor.
So he left after this altercation?
Yes.
How did he leave?
And drove away.
And so you were alone that night? That's your testimony today, correct? With the children? In his house, correct?
Yes.
And then what happened the next day?
I don't remember.
Do you recall when you testified about Mr. Kennedy going to the hospital? That
Yeah.
you went to a neighbor's and you had a neighbor drive him, correct?
Yes.
He had an inflamed, infected arm, correct?
Yes.
How many days after this assault that we're describing today did that occur?
I do not recall.
Was it less than 5 days?
I do not recall.
Was it less than 10 days?
I want to say yes.
Now, at some point after all this occurred, you decided you were going to call the police, correct?
I did not call.
So you did not call the police. How did you come into contact with the police where they took a photograph of the blackout?
Somebody had called their services on me to do a well visit. And the day before he went to the hospital, they showed up to check on me.
So it's your testimony, you did not call
I
911.
didn't know.
Someone else.
Somebody else called.
Do you have any idea who that person is? Have you talked to anyone about that?
No.
Do you know what day that was that this came to not to your house, but to Mr. Kennedy's house?
And I'm sorry to interrupt, but I would just ask the question to be more specific.
When they came and took the photo, what day was it?
Day the police report is.
I'm asking if you know.
The day of the police report, it would be the day he went to the hospital.
So it's your testimony that that you called or had a neighbor take Mr. Kennedy to the hospital the same day that the police came and took her picture?
Yes.
Had he come back to the home then? It sounds like he had after we left on the night of the 27th.
Well, I'm sorry.
So your testimony is that he left after the fight? Correct.
It was, yes.
And then he come back and spend the nights at the home after that?
I cannot remember the gap. I believe it was like maybe 5 to 10 days gap between from the fight to be shown. Or a span of 5 to 10 days of the fight happening to the police showing up, then him leaving, and then me leaving the days. That's the best.
So you don't know, came back to the house and spent the night between the time that this fight occurred and the police arrived on the well the checkout call?
Oh, I can't say yes or no. I want to say yes. He did because I explained, the police officer showed up and I told him not to please leave because he was home.
So it's your testimony he was still home, he hadn't yet gone to the hospital on the day that the police came? I'm sorry, I'm just trying to figure it out myself. So You don't know whether he was home when the police came on the day that they arrived and took the picture?
That's the day he went to the hospital, and I, about 2 hours, an hour and a half to 2 hours prior, when they took that picture. The first time the police officers came to the house, he was home.
So the police officers came to the house on some day, you don't know when it was, correct? After the 27th,
Yes.
he was home.
I don't know the timeline, I'm sorry.
Well, I'm just asking if he was home, not the day.
And Judge, I would again, the complaining witness has testified she lacks knowledge.
Is that an objection?
Yes, Judge, I object to that, because the complaining witness just testified she lacks knowledge. I would ask that maybe the question here if there is.
All right, I'll ask one more time. It was Mr. Kennedy home. He first came to your house. First time you saw him after he assault, he got a scrub.
Yes.
He was home. Then there was yet another time.
Then the following time, he came home from work. It was, I don't know if it was the next day or the next day, I believe it was the following day, he said he fell off the roof at work. Oh, he got bit by a round of spiders, and that's when he sat on the couch. I went to call 911 and hung up because he told me not to. So then I went next door and got the neighbor into the hospital. About an hour and a half to 2 hours later, the police showed up to revisit their initial visit day prior. And he was gone.
So when the picture was taken, Mr. Kennedy is not there, correct?
Correct.
That's your testimony today?
Yes.
And after Mr. Kennedy went to the hospital, did you continue to stay at that home?
I guess, for that night.
And the children were there also?
Yes.
And how long did you stay there? How many days?
I stayed there for 1 night. And left that morning.
Where did the children go?
They went with me.
And then you had your own car?
No, I had gotten it next door.
And did you have custody of the children at that time?
I believe I did.
Objection, Your Honor, complaining witness previously testified she lacks personal knowledge as to what any custody of one was at the time of the incident.
If a witness can't answer.
But did you know? I did not know the legal rights and I stood at that.
You did though take the children?
Yes. As a, also as.
I didn't ask the question. I'm trying to decide if there's any more questions. I'm going to consult with my client.
Yes, ma'am.
It's a long question. Do you know how many days went by between the, fight that you described, and you got the black eye, and police taking the picture of that black eye?
Objection, Your Honor, asked to be answered.
I haven't asked that specific question.
The objection's overruled. She may answer the question if you know.
Thank you.
Not know the exact days, but I believe it was a couple of days.
Thank you. Jeanette.
No, Your Honor. Thank you.
Ms. Landon, thank you. Your next witness, ma'am.
Your Honor, the people have no further witnesses.
Ms. Dunn, anything? Argument.
Your Honor, at this time, I would move to amend the information of specifically count 2 domestic violence. It currently says did make an assault or assault and battery upon Sherry Elizabeth Lannon, a resident or former resident of his household. I would move to amend that to include a person that he had a dating relationship with and or a person that had a child with. And I can of course submit the information report.
Ms. Dunn?
No, I really can't object to that, though, witness did testify to both, staying with Mr. Kennedy and Mitchell.
Thank you.
And then, Your Honor, at this time, I move to bind over on all counsel Missouri.
Ms. Dunn?
Your Honor, I'm not going to make an argument that there wasn't probably cause, established here today. And it was hearing one.
Understood, thank you. Anything else, Ms. Mandernack?
No, Your Honor.
For having had the opportunity to hear from Ms. Lannon and hear the argument of the attorneys involved, the court will bind Mr. Kennedy over as charged. Mr. Kennedy, your next court date will be 2 weeks from today. That will be March the 19th, 2025 at 9 a.m. at the Criminal Justice Center in downtown Detroit. Your previously entered bond with any of its conditions will continue. Ms. Mandernack, is there anything else on behalf of the people?
No, Your Honor.
Ms. Dunn, anything else on behalf of Mr. Kennedy? Mr. Kennedy, that concludes the matter in district court. Good luck to you, sir. Have a good afternoon.
Thank you.
Have fun.
And Judge, that is all I have for you, but I will be here to your meeting.
I'll see you next week. Thank you, ma'am.
Thank you.
Officer Raff, if you would grab Ms. White and Mr. Mohammed, please. We are so close.
These will be in a room and that's a fire.
Hey,
You just told me that you wanted this last.
oh no, I said to grab you and Miss White on Cabell,
Oh,
the 12 o'clock exam.
okay, I think there's a be on the 1 o'clock, so maybe we can do that first.
Absolutely. Mr. Michael McKay?
Yeah, the result for one?
Absolutely.
You know what? Next Wednesday, we have 4 exams.
Okay, we need to talk about that because this 12 o'clock meeting is a recurring meeting, at least for the short term. I need to fix that because I know that we have, yeah.
Every Wednesday, you're gonna have this? Okay. So do you wanna start your exams at 12:30?
It's from 12 to 1. That's why we'll have to look at the
Okay.
docket and figure it out because I know when I said the 12 and 12:30 today, we'll figure it out. We'll talk about it. I'm just saying it out loud to you because that gives us time between now and next week to, or now and end of the week. Get it
Because you
straight.
wanna change those times.
I think so.
We could do it at, did you say 12 to 1? That's when you're meeting?
Because there's only 4.
Yes. 2 at 11:30, 12, 12:30.
We might push the 12 and 12:30 back to 1 o'clock.
Okay.
Because the 2 11:30s, are they really going? Was it Mr. Noakes and Ms.
Right.
Frederick? Were they both Ms. Frederick? No,
And then Carrie has the other
the
two.
one that was adjourned.
Yes.
Okay. Who I thought was who just walked in the courtroom. That's what I thought it was.
Well,
This is the exact opposite of what I thought was happening.
Judge, she's speaking to her client for the police, so we're just.
Thank you. This is 240790 FY, State of Michigan versus Devin Cabell. Your
And good afternoon, Your Honor. Reason why on behalf of Mr. Devin Cabell, he's 63046.
state your name for me, sir. Thank you, Mr. Cabell. Today is the day and time scheduled for the preliminary examination in this matter. There is count one, receiving and concealing stolen property. Count two, misdemeanor traveling with it of letting a suspended person operate. And count three, misdemeanor of open alcohol container in vehicle. Mr. Mohammed, Ms. White did file a motion to dismiss for failure to comply with discovery rules. Have you had the opportunity to discuss this issue?
Correct, Judge, and as I informed defense counsel prior to that motion, there's no digital in this case. I referenced the OIC's email. I believe she just wanted some confirmation from the OIC. And so I did take her up to the OIC here in the courtroom today. Sergeant Cadez, and he confirmed with her that there's no digital in this case. And he stated his reasons. What was it?
I don't need the reason on the record. Ms. White will confirm whether or not her concerns have been satisfied and whether we are proceeding on the motion or the motion is being withdrawn.
Well, today is the day that I did hear from the OIC indicating that there was no video of the working for the car. So I'm taking this as an officer of the court his stance, and I talked to my client and we'll just proceed with exam and waive the motion.
Okay. Mr. Mohammed, is there any other preliminary matter on behalf of the people? Ms. White, anything before we proceed?
That's great.
If there's anyone in the courtroom who is giving testimony in this case at this time or at any foreseeable time in the future, they should absent themselves from the courtroom. Same thing. We are streaming this matter. If there's anyone who is viewing this case who is likely to give testimony today or at any time during the life of this case, they should stop viewing this case. No one's exited the courtroom. Mr. Mohammed, your first witness, sir.
People call Sergeant Cadez.
Sir, I'm gonna have you come all the way up to the black chair that's closest to me, please. And before you sit down, if you would state your first and last name and then spell them both for the record.
Sergeant Rick Cadez, RICKCAVEZ.
Raise your right hand for me, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you much. Have a seat in that chair for me, please. My secretary is recording your testimony. If she's having any trouble hearing you, I'll ask you to either raise your voice or move closer to the microphone, okay?
Yes, sir.
Thank you. Mr. Mohammed, your witness.
Sergeant Cadez, can you please state your full name for the record?
Yes, Sergeant Rick Cadez.
Sergeant Cadez, are you currently employed?
Yes, sir. I'm employed with the Wayne County Sheriff's Department.
Okay, and in what capacity?
I'm a sergeant in our local patrol unit.
Okay, and did you work the day of September 26, 2023?
Yes, I did.
Okay, and on that day, did you work in the capacity as a sergeant for the sheriff's office?
On that day, I was the corporal. I've recently been promoted, but yeah, I was working as in the capacity of a local patrol officer.
Okay, and on that day of September 26, 2023, did you work in full uniform or modified uniform?
In full uniform and a fully marked patrol vehicle.
Okay, and on that day, your duties as a police officer take you at or near the location of the Middle Belt and Metroplex?
Yes, they did.
Is that located in the city of Romulus, County of Wayne?
Yes, sir.
Okay, and when you were at or near that location, did you observe something that drew your attention?
I did.
What drew your attention?
I was on patrol southbound Middle Belt near Van Born, at which time I observed a white pickup truck driving with no rear lights. I approached the vehicle and observed that the license plate attached to the vehicle had an expired plate of 2021.
Okay, and so did you conduct a traffic stop on that vehicle? How did you conduct a traffic stop?
Activated my emergency lights in the area of Middle Belt and Metroplex. Vehicle pulled off of Middle Belt on Metroplex, and I initiated traffic stop.
Okay, and just for clarity for the record, what was the reason of that stop?
The reason was for driving with no rear lights and the expired license plate.
Okay, and are those ticketable offenses?
Yes, they are.
Okay, and did that vehicle pull over?
Yes, it did.
Okay, can you describe that vehicle?
It was a 2021 white and color Dodge Ram.
Okay, and when that vehicle pulled over, did you approach the vehicle?
I did.
How many individuals were in the vehicle?
I believe there's 2 individuals in the vehicle.
Objection, speculation.
If I could refresh.
I'm sorry, give me 1 second, Sergeant. Your response to her objection?
Well, Judge, I would actually agree because he used the words "I believe," and so I think it's that he's not sure. So I would ask him not to speculate, and I would ask him so I would ask that to be stricken.
Well, not stricken. The court will sustain the objection. And then if you want to ask a different way and Sergeant Cadet wants to respond.
Officer, and yes or no, do you know how many people were, or I don't know if that's. Do you know how many people were in the vehicle?
I believe if I could refresh my memory of my report, the individuals in the vehicle would be notated in the police report.
Okay, so as of right now, you don't recall.
I believe it to be 2, but I'm not 100%.
Okay, so would referring to your report help refresh your recollection?
Yes, sir.
Okay, you can turn to your report and refresh your recollection. Your Honor, may I approach the line?
Yes, sir.
Even this 1 more page.
Okay. Would it be in there?
Yeah.
Just pull out the documents so I can hand it to the.
I believe you have in your stack, it's the top pages.
Does it?
Keep going, whatever. Please make sure.
Okay. Oh, man, I know. I'm just looking.
No.
Take a moment. What's your memory? Then we'll look at it.
Yes, no.
Okay, how many individuals were in the vehicle?
There were 2.
Okay, and the individual that was in the driver's seat, do you see that individual in the courtroom today?
I do.
Can you please point to that individual and point out an article of clothing that this is wearing?
The individual is wearing a black button-up shirt. He's sitting to the left of counsel.
Your Honor, let the record reflect the witness has identified it.
Yes, sir.
Thank you. And so what did you do did you make contact with the driver?
Yes, I did.
And so what happened?
I made contact with the driver and asked him for his driver's license, registration, proof of insurance. The driver was identified later as Mr. Gable, was unable to provide those documents. At which time I asked him if he was the registered owner of the vehicle. And he stated that the vehicle was his brother. I asked him for his brother's name, at which time he became evasive and stated that the vehicle was a friend of his.
Okay, and what happened next?
At that time, I asked him for his name and date of birth, which he provided. When I was getting all that information, I observed the back right passenger side of the pickup truck that had a broken window. At that time, I had him exit the vehicle and he was detained for not having a valid driver's license on him to further my investigation.
Okay, and what did you do to further your investigation?
I went back to my patrol vehicle and ran a lead check on the license plate that was attached to the Dodge Ram. It was determined that the license plate that was attached to the Dodge Ram came back to a 2007 Cadillac. At which time I went and verified the VIN on the 21 Dodge Ram pickup truck. I ran that VIN through Lean and it was confirmed stolen vehicle out of Canton earlier in the year.
Okay, now you indicated there was a broken rear glass.
Yes, sir.
That alongside with the improper plate, based on your training and experience, is that indicative of anything?
It's indicative of a stolen vehicle.
Okay, and you indicated that you had reviewed the VIN number associated on the vehicle and put it into Lean and found out it was stolen, correct?
Yes, sir.
Now, do you recall what the VIN number associated it was?
I do recall the last 6. I do not recall the full VIN.
Okay, with reviewing that, the incident report associated with the case, would that help refresh your recollection?
Yes, sir.
Go ahead and review that, and once your memory's been refreshed, just look up at me.
Yes, it's refreshed.
Okay, what is the VIN number associated with the vehicle?
The VIN number is 1 C as in Charles, 6 Sam, I'm sorry, I'm so used to 1 C 6 S R F L T 2 M N 514777.
Okay, thank you. And so what did you do next after you ran it through the Lean and confirmed it was stolen? What happened next?
At that time, it was confirmed that it was stolen. I requested assistance from another officer and made contact with the passenger.
Okay, and what happened next?
I made contact with the passenger. My backup arrived, and at that time, in speaking with Mr. Cable, it was determined that I could detect the smell of toxins emitting from his breath. I asked him if he had been drinking. Stated that he took a shot, White Star Lemonade. I asked him if he had submitted sobriety test.
Understood. Did you have an opportunity to speak with the victim associated with this case?
At that time, no. After the further investigation, I did.
Okay, and did you learn the name of the victim?
I did.
What is the name?
I would have to refresh my memory on.
Would that help refresh your recollection?
I would have to reference the original police report.
Understood. This one?
It's.
Do you have a copy of it?
What's that?
Do you have a copy of it?
I do.
Okay,
Can I reference it?
yes. That helps, I'll just request a copy to show. Yes, it's just refreshing. For that. And once you locate that document, just hand it to me. Something for. Let's see what it's for witness.
Yeah, it's like.
Good.
Yeah, so.
Has your memory been refreshed?
Yes, it is.
Okay, what's the name of the victim?
It's Jacob Dooley.
Okay, and did you speak to him as to whether or not anybody had permission to drive that vehicle on that day?
I did.
And what was his response?
That no one had permission.
Okay, no further questions.
Thank you. Ms. White.
Yes, thank you. Well, good afternoon.
Good afternoon.
Okay, so were you independent in your vehicle or were you with a partner?
Yeah, we work single man patrol, so I was by myself.
Okay, and it's fair to say that this was around, it was dark, correct?
Yes, I believe it was 2037 in the evening.
Okay, and did you complete an investigator's report?
Yes, ma'am, I did.
And you named yourself number 1599 Corporal R. Cadez?
Yes, ma'am.
Okay, and do you recall entering a data complaint of November 21st of 2023?
If you could clarify, what does that mean?
The complaint that when the complaint was written, you wrote the complaint was written November 21st, 2023.
Okay, when I would have submitted the investigator's report. Is that what you're?
Want me to, may I approach?
Yes.
Yes.
Okay, However, this allegedly occurred back on September of 26th of 2023, correct?
Correct.
Is there a reason why 2 months? I mean, was it-
Yeah, that's when the actual case was submitted to the prosecutor's office. The delay, if you're asking, is that what you're asking, what the delay?
why
was?
there's different dates from the date of the alleged incident to the date of the complaint?
So on the complaint is we have the date of the offense, and then we'll have the date that we actually submit the investigator's report.
Okay, so it's fair to say was Mr. Cavell, he was arrested, correct?
Correct.
Okay, and there was no warrant submitted for him to go before a magistrate for an arraignment on warrant, no charges filed?
Judge, I'm not sure, I don't see how that's relevant to probable cause in this case, but I don't know. The date of submission of the case.
Ms. White?
Your Honor, this is, I believe it's relevant, given the fact that if there's allegations that my client committed a crime, he was arrested, he was asked to make statements, there was observations of the vehicle that was listed as stolen, and 2 months later, he's arraigned or he's charged. I'm just questioning the line and sequence of events, chain of events that occurred to really determine the real true actual belief in this matter.
I'm gonna overrule the objection, but Ms. White, if you're getting somewhere, let's get there, please. I said, if you're getting somewhere, let's get there. Thank you.
Okay, so on September 26, 2023, did you, Mr. Bill was arrested, correct?
Correct.
And did your department just release him or was he charged?
He was arrested and booked into the Wayne County Jail, and then he was subsequently released the next day pending a submission of out of custody warrant record.
Okay, so you hadn't submitted the warrant, you were just planning to put together an out of custody warrant?
It was determined the next day that he was gonna be an out of custody warrant record due to manpower issues.
Okay, now when you had contact, you indicated there was another individual in the vehicle, correct?
Correct.
And that person was in the rear back passenger,
I believe that person to be the front passenger.
front passenger, do you believe? No.
I believe.
Okay,
Judge, I'm gonna object to that motion.
I would concur.
Your objection sustained. Ms. White, do you want to rephrase the question or?
Okay, so where was the second person that you indicated there was 2 people in the vehicle? Where was that person located in the vehicle?
Again, I believe the individual to be the right front passenger. I'm not 100% certain that was the location.
Okay. And now when you testified that the main purpose or pretext of the stop was there was pretty much no rear lights activated, correct?
And an expired plate.
Okay. And when you indicated expired plate, then you subsequently ran the lean on the plate to determine whether or not it matched the vehicle?
After making the tracks.
And do you recall placing that issue with the different, the different license plates? Did you place that in your report, that information?
Can you repeat the question?
Was that information that you testified to in terms of the plate being the wrong plate connected to the vehicle? What, did you enter that, do you recall entering that into your investigator's report?
Yes.
In your police report?
Yes.
Okay. Now, when you talked to Mr. Cabell, you indicated that he indicated it was first, it was a relative's car that he was driving, correct?
Said it was his brother's.
And then he stated it was a friend of his brother's, correct?
He stated it was his brother's, and when I asked him what his brother's name was, then he changed it and said that it was a friend's.
Okay, and you also testified that then after the questioning, you looked around in the vehicle, around the vehicle, and you observed the back passenger rear window broken.
Correct.
Okay, now did you observe or assess the vehicle any other way or any more in the vehicle?
I don't understand the question.
Did you do a kind of a viewing of the vehicle to see if there were any other issues with the vehicle?
No,
Okay, did you check whether the ignition was punched?
it was not.
And did you also verify whether there was actually keys used to turn on and off the vehicle?
There was keys with the vehicle.
Okay, and were you aware of whether these keys all were connected to wireless or, you could just turn the car on without opening the vehicle itself?
Again,
Yeah.
use that question.
Okay, key fob, you're aware of what a key fob is?
Yes,
Okay.
it was a key fob,
Was this a key, did you observe a key fob or keys or both?
a key fob,
Okay, and they were both intact?
yes.
Okay. And there's fair to say that there were no issues with the actual, I guess you would want to call opening of the vehicle, that you would open the vehicle, there wasn't any compromise to the vehicle opening?
No, I didn't observe any damage or compromise to the key entry.
Okay. Now, when you ran your lien to determine that the vehicle was stolen, what date was the vehicle listed as stolen? Date, month, date, and year?
I would have to refer to the paperwork.
That would refresh my memory.
Okay, my memory is refreshed.
Okay, please go ahead.
It was listed as stolen on March 22nd of 2023.
Okay. Had an observation of this broken glass window in the rear of the truck. Did you question Mr. Cavill as what, do you know why this window was broken? Did you ask him any questions of that sort?
Once Mr. Cable was read his Miranda rights, he was answering questions.
Did you notify Mr. Cavill that the vehicle was listed as stolen?
I do not recall.
And per your report, is it fair to say that this vehicle was, there was a hit out of Canton, Michigan, where the vehicle was reported to be stolen from?
That's correct.
Nothing further at this moment.
Thank you. Can you redirect Mr. Mohammed?
No further questions for this witness.
Sir, you may step down. Thank you for your testimony. You're welcome.
I'm gonna be calling one more witness, just the victim, and it will be very brief. Jacob, you're done.
Sir, if you would step up here for me, please, to this black chair that's closest to me.
Judge, is it okay if the OIC remains in the courtroom?
Absolutely. And sir, before you sit down, if you would spell your first and last name for me.
J-A-C-D-U-I, spelled pronounced Doobie.
Mr. Doobie, raise your right hand. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? You have to say it.
Oh, yes.
Thank you, sir. You may have a seat. My secretary will be recording your testimony. If she has any trouble hearing you, I'll ask you to either raise your voice or move your body closer to the microphone, okay?
Okay.
Thank you. Mr. Mohammed.
Thank you. Mr. Doobie, can you state your full name for the record?
Jacob.
Michael Doobie. Mr. Doobie, I want to take you back to the date of September 26, 2023. On that date, was your vehicle listed as stolen,
Yes.
reported as stolen?
Yes.
And you had reported that vehicle stolen prior to that date, correct? Do you recall the day that you listed your vehicle as stolen?
Not off the top of my head.
Okay. One moment. please.
Yes.
Mr. Doobie, how are you associated with this case?
My truck was stolen from the parking.
Okay, and can you describe your vehicle?
It was a 2021 white Ram 1500 Rebel.
Okay, and this truck, do you recall the VIN number associated with the vehicle?
Now, off the top of my head,
Do you have anything with you that would help refresh your recollection as to the VIN number associated with your vehicle?
I have the claim information from the insurance agent.
Would that help refresh your recollection? Okay, can you pull it out? I'll just have to show it to the defense.
Is the release of title from my bank to Progressive Insurance. Look at it.
Okay, you can refer to it and refresh your recollection when your memory's been refreshed, just look at me.
You need the VIN number.
Yes.
The number 1C6 SRFL T2 MN 51477.
Okay, thank you. And nobody had permission to take that vehicle, from you, correct?
No.
Okay, no further question.
No question.
Mr. Duke, thank you for your testimony. You may step down.
Judge, one more, no further witnesses.
Anything, Ms. White?
No witnesses.
Argument?
Judge, I'm gonna vote for a bind over. I believe the testimony reflects a question of fact for the trial fact.
Your Honor, on behalf of Mr. Cabell, I will respectfully disagree with a bind over on these charges, specifically count 1. I understand count 2 and 3, they're misdemeanors. With regards to this receiving and concealing stolen property motor vehicle, we all know what the elements to this actual crime is. Is that a person received, possessed, concealed, or aided in the concealment of what was testified to a 2021 Dodge Ram, a stolen motor vehicle, knowing or having reason to know that the vehicle was stolen. Now, my client was in the vehicle and there was allegedly some issues that pretextually, put forth a stop to the vehicle that was already testified to. However, in terms of the plates being different and, him driving to the point that he had the grounds to stop him, we need to actually connect along with the broken glass, rear passenger window, broken glass. We have to connect. Really, how Mr. Cabell had reason to know or knowledge that a vehicle was stolen? He told a police officer it was my brother's. And then he made a statement that it's my brother's friend or a friend of my brother. Does those two matters equate to I know a vehicle is stolen or have a reason to know that a vehicle was stolen? This officer testified that he didn't even notify or advise Mr. Cabell that the vehicle was stolen, or I can't remember. That was pretty much the officer's testimony, the corporal's testimony. What we have here is, I know it's a slow burden, it's probable cause, but we have to show possibly more than probably or not, probably, that my client committed the crime of receiving and concealing stolen vehicle. I don't believe there's enough to establish that Mr. Cabell had knowledge or reason to know that the vehicle was stolen. Having a traffic stop affected, having a vehicle with a broken window in the rear passenger, and there was also another passenger there was no testimony that anything happened to that person, was broken out, and he had bad plates. He already said that this vehicle was his brother. His brother may have let him borrow the car, but never said, hey, let me tell you, it's stolen. You just don't know. You take a car, I can take my sister's car and not know it was stolen. So Your Honor, overall, I'm going to argue again the fact that we have to show enough, possibly, probably enough. A broken window, no punched ignitions, key intact with the fob, and also just bad plates. He's not Secretary of State. My client is not a Secretary of State that he can run the plates and say, let me check first before I drive this car. Nothing. So if we have reason to know or knowledge, where is the knowledge? Unless Mr. Cabell specifically indicated, yeah, my brother, or I knew it was stolen, or I think it was stolen, that would be a different issue. But there was no testimony or statements made of that sort. So really the elements don't fit under the probable cause standard that my client had knowledge or reason to know. He was just driving. And there was nothing to show that he even knew the vehicle was stolen, other than a broken glass. And I don't know any Supreme Court or appellate court decisions that based on a broken glass and some bad plates that weren't even run or notified that they were pretty much connected to a stolen vehicle, that would establish or amount to receiving and concealing a stolen property that now my client is being charged with. So I'm gonna request that charge be dismissed. Thank you.
Mr. Mohammed.
Judge, I disagree. I think what the testimony shows is a question of fact, for the trier of fact. What we know is that this defendant did not have permission to be in that vehicle or to drive that vehicle. He also couldn't even provide a person who was owner. First he said it was his brother, then he said it could be his friend, and then so on and so on. So it sounds like he doesn't even know. People don't just take people's cars without. He should have reason to know based off of the totality of the circumstances. The windows are busted. The window is busted, my apologies. He's in possession of a vehicle that's not his and a vehicle that he doesn't have permission to be driving. So I believe, and also there's an improper plate on the vehicle. The plate isn't even associated with this vehicle. I think the officer indicated it was for a Cadillac and what we had was a truck. So again, I think there's a question of that for the trial.
Thank you. Ms. White, the court having had the opportunity to hear the testimony of Mr. Doobie and Sergeant Cadez, the court will find that the people have met their burden as relates to count one. There is a question of fact that can be taken up downtown, whether driving with no rear lights on, having a 2007 Cadillac plate on a 2021 Dodge Ram, broken window, brother's friend's truck, are sufficient reasons to get to the receiving and concealing of a stolen motor vehicle. Mr. Cabal will be bound over as charged. The next appearance date will be an arraignment on the information on March the 19th, 2025 at 9 a.m. at the Criminal Justice Center in downtown Detroit. His previously entered bond with any of its conditions will continue. Mr. Mohammed, anything else on behalf of the people?
No.
Ms. White, anything else on behalf of the defendant? Thank you. That concludes this matter. Mr. Cabal, I wish you the best of luck downtown. You have a wonderful afternoon, sir. Thank you. I have not seen Mr. Ignazi. Ms. Dunn, are you standing in for Mr. Ignazi? Thank you. Absolutely. Absolutely. So it occurred to me that in the 50 million times you all have both heard me say that I'm married to an elected official, blah, blah, blah. It's only the second time that somebody has asked the case to be reassigned. Yeah. The other case was, I remember who the attorney was. I don't remember the case. But I remember who the attorney was.
Someone that comes in here often?
Not anymore.
Oh.
It was back in the beginning.
Oh.
But today I was like, that's not a good move for me.
It's almost saying that the defendant has been are involved with me. What?
I was like, I don't know who they are, but
it's like.
So you understand that we don't all know each other. I have no idea. The name didn't even mean anything to me.
I'll be right back.
What?
Like,
What does that mean?
right, go on.
That's age. When you said, I thought you said Campbell, when I went out there, I'm like.
Oh, I'm sorry. No,
I didn't know, yeah.
We were so close to done. Just one more case. Just one more.
But it'd be interesting to see, okay, you had the key fob. Did the guy leave the key fob in his car when he was stolen, stuff like that?